shorthand for Susan Crichton?
For the legal team, yes. I think it was Susan Crichton and Hugh Flemington who were at the meeting.
It says that this has happened, or it's Alice's view that this has happened throughout the process. Was that a view that you were aware of, that the business was pushing back unnecessarily against a review throughout the process?
Not until I spoke to Alice, which I did, I think, on the Saturday morning. I was concerned, and so if a chairman raises issues like this, I wanted to know what had arisen.
Did you think that Mrs. Misra's case should be included in an independent review?
I wasn't even involved in the conversation about that. My view was that all the cases that had come forward through Lord Arbuthnot and thereafter from other MPs, we were going to review all of the cases.
Did you share Miss Crichton's concerns recorded here that even contacting Miss Misra would be a red rag to a bull?
No.
Did you know that Post Office was getting external advice on the effect that bringing such cases within the review would have?
Well, clearly I did, in the sense that Alwyn mentions it in the final line on this email. I don't at that stage think I would have asked more about it, because the situation was resolved in that all of the cases were going to come in. If Susan was seeking advice on something of a legal nature, I would expect her to do that, and then I would listen to whatever that advice was.
Do you know what external advice the Post Office did take regarding the effect of including cases like Seema Misra's in the independent review?
I don't think so. I certainly didn't see the Richard Morgan advice.
I don't think there was a written advice. There was a meeting with him.
There was a meeting note, right, yeah. I don't think I did, no.
Have you got a date readily to hand to remind me of when that was, Mr. Bean?
Given a moment, I probably could.
I'm sure we'll find it between us. Don't take yourself out of your stride.
Thank you. Did you know the substance of the advice, the external advice that was given?
No, not until I read it in preparation for the inquiry.
Did you and therefore the board take not take the advice given, as you now know, by Richard Morgan and KC into account in deciding the scope of Second Sight's review?
No, I don't believe. You would have to ask Alice Perkins, but I don't believe that Alice Perkins or the board knew of that advice. But Susan had a conversation with Alice that I was not involved in, so it's possible it was shared in that meeting, but my understanding is not.
Thank you. Can we move on into 2013, please? And look at poll 0010-0200. This is a minute, I think, from, as we can see, David Oliver to you, copied to others, of the 5th of February 2013. Could you explain who David Oliver was, please? David
Oliver, I believe, was on a short-term contract, maybe a year or two. He was either a consultant with PA Consulting or had left them and came to the Post Office and was working on the Project Sparrow work. In fact, looking at the list, what date is this, please?
5th of February 2013.
2013. No, he was working on the Sparrow project.
He sends this minute to you and others regarding essentially options that the Post Office could take to deliver the scheme in a timely fashion. You can see that there.
Yes.
Under summary. We identified 3 broad courses of action that might be taken to improve the ability of Post Office successfully to deliver the mediation scheme in a timely fashion. Can we look at page 2, please? And scroll down to what was the third option, Plan C, a contingency plan to replace Second Sight if they refuse to work on the scheme under terms which the Post Office find acceptable. Engagement of a professional accountancy firm such as Grant Thornton to replace Second Sight entirely. It's possible that Second Sight will refuse to work under the proposed terms of engagement from the Post Office, and that they may attempt to insist terms that neither you or the Post or the board can accept. In this scenario, they may either walk away from the scheme or Post Office may have to end their engagement. Was it the case that despite their appointment in mid-2012, no terms of reference or terms of engagement had been settled by February 2013 for Second Sight?
I don't know about terms of engagement. I do know that that terms of reference were drawn up. Engagement, I don't know. That wouldn't have been something that I would have been involved in.
By this time, was it anticipated that Second Sight would refuse to work under the terms of engagement that the Post Office required?
It seems to say so here. I don't recall being aware of that, presumably until this was presented to me, and I'm not entirely sure what that refers to.
Do you know which of these options was chosen? Do you want to look back at options
yes,
A and
please.
B,
Yeah.
please? On page 1, please. A was clarification of Second Sight's engagement.
Yes. I think A and B, actually. So my recollection at this stage is that there were concerns from the team that very few cases had been reviewed. The time was being extended and therefore the cost extended. And I think that was the main concern, is that the work, for whatever reason, wasn't being completed. And I was given a number of options. I'm sorry, I don't remember the discussion, but my sense is that it was, we want a Second Sight to see this work through. It would have been difficult to stand somebody else up, I think. And anyway, they had the commitment of Lord Arbuthnot and the MPs. But I do think we brought in or changed the way they worked in some way to help them. But I may be confusing that with the mediation scheme, because this issue of time and cost overrun was a fairly frequent topic of conversation.
Can we move forwards to later in 2013, still before their interim report was produced, by looking at poll 3098437. And looking at page 2, please. And if we just look at the foot of page 1, we'll see an email from Mr. Bates to you of the 21st of May 2013. And he says, "Hello, Paula. It's been a while since we met at James Arbuthnot's office, but at that time you did say that if I had any concerns, I should contact you directly, hence the reason for this email. Would it be possible for Kay Linnell and I to meet you? You recall that Kay is an independent forensic accountant who, on behalf of JFSA, has been monitoring the work Second Sight has been undertaking. The main purpose of the meeting is to ensure that you have been receiving the full details of what has been occurring with the Second Sight investigation. Bearing in mind what has been discovered so far, I, for one, am surprised that we haven't yet met to discuss the implications. Whilst I appreciate the majority of the issues began under previous regimes, and you've expressed a genuine willingness to address the concerns that JFSA has been raising, these issues are still continuing. I've little doubt it's now feasible to show that many of the prosecutions that the Post Office has pressed home should never have taken place. I believe this is a view shared by Kay." At this point in time, did you understand why Mr. Bates was saying that it was feasible that many prosecutions that the Post Office had undertaken should never have taken place?
I don't believe I did, because we were still waiting. The work was still very much a work in progress.
Had any of the in progress work been fed back to you, i.e. provisional views, what it was showing, early themes, emerging issues?
Not that I can recall with any clarity, because I remember being surprised about, I think slightly, what is the date of this, please?
21st of May.
Of May. Maybe not too long after this, but as we were approaching the production of the interim report, I remember being surprised about some of the conclusions that were being reached, because the criticisms from Post Office were that their work hadn't been taken into account. So I think at this stage, possibly not, other than feedback that the work was going too slowly and Post Office's input either hadn't taken place or Second Sight, there were concerns being raised perhaps that Second Sight were not taking account of it.
Would you have been very concerned reading an email like this, that the person representing a key stakeholder, JFSA, was saying that the prosecutions, and many of them that the Post Office had brought, ought never to have taken place?
I was concerned to get the email from Alan, certainly. The point he's making about the prosecutions was the point that the JFSA had made for, I now know, for a number of years, but that wasn't new news to me at this stage.
Is that how you would have thought of it, that this is just Mr. Bates saying something that he's always said?
No, not at all. I think that I went back to my team and said, because I had said to Mr. Bates that, you know, if he needed to, he should get in touch. So I don't know if there's documentation on this, but I'm pretty sure that I went back to the team and said, what should we do about this? You know, I've offered to meet Mr. Bates. What is your view?
Had you been given any inkling that anything had emerged that might undermine the safety of convictions?
No.
If we go to page 1, please, we'll see your reply. And if we scroll up, you say, I am, second paragraph, happy to meet, but can't make the suggested date. And then the third paragraph, my understanding is we're too early in the investigation to suggest that things have been discovered which call into question the integrity of the system or the validity of the prosecutions, and to suggest that at this stage would be wrong. In order to say that, you must have been told, would this be right, at the stage at which the investigation had reached, and whether it was possible to say that the integrity of the system or the validity of prosecutions had, even at that stage, been called into question?
Yes.
And who were you getting that feedback from?
At this stage, I would have talked to whoever was leading the work on this. So Susan Crichton, Alwyn Lyons, I can't remember who else, Simon Baker, presumably David Oliver, whose name we've seen.
And so were you then getting feedback on the state of the investigation by Second Sight in order to be able to say, essentially, Mr. Bates, you're jumping the gun?
I'm almost certain that when I got Alan's note, that I went to the team and said, I've had this note, what's the current status? And as I say here, I would like to meet with Mr. Bates. So I suspect that's where I got that information from.
You say in the last paragraph, I've been advised that Second Sight have now agreed that the focus over the next few weeks will be on 3 specific cases. And the meeting might be a more productive one when that work has been completed. Do you know how it came about that what started as a debate between the choice of Deloitte conducting a full forensic audit of Horizon Second Sight conducting a review of past cases that would be a representative sample, but include some testing of the integrity of the Horizon system, ended up with focusing on 3 cases?
My recollection is that the team, what I can recall is frustration from the team that the work Second Sight was doing had moved away from focusing on individual cases to development of themes. And what they were trying to do at this stage, and Second Sight as well, to be fair, was to try and corral this back into a piece of work which could have a report which could be fed back to the MPs before we got to recess in just a small number of weeks after this. That's my recollection, and that was to misuse a word in this context, but that was the theme that ran through, which was Second Sight were focusing on themes rather than on individual cases. And at some stage, we will come on to how that then developed into spot reviews, which I think came after this.
And so was it the Post Office, in your view, or Second Sight that narrowed focus down to a very small number of cases?
My view is it was both, because both Second Sight and the Post Office had a commitment to Lord Arbuthnot and the MPs to get some work out for people to look at, and we were now not quite a year, but sort of 10 months into this. That's my recollection.
Were you aware of a view amongst the lawyers, and in particular Susan Crichton, that if we review a large number of cases, that might open the floodgates to damages claims by sub-postmasters?
No.
And that a less risky approach would be to just pick the cases in which the MPs happen to be interested in?
No, I don't remember that at all.
Can we go to the... this is slightly out of order, but it's in order to answer the chairman's question from earlier. The Richard Morgan Casey advice. It's poll 406484. And the date says the 12th of June, 2012. I think this is the advice. We'll see in a moment that it's recorded as a note of an in-person conference of which you weren't aware.
That's right, yes.
And to the best of your knowledge, the board was not aware.
No, I don't believe so. The only person who could possibly be aware might have been Alice Perkins in that conversation Susan had had. But actually, looking at the date of this, I think this comes afterwards, doesn't it?
Yes, if we look at the second bullet point, the proposal to instruct an independent expert to prepare a report on the system is the highest risk response to the issue. Was that view communicated to you?
No.
In fact, a decision had been made, it seems already, at the meeting of the 7th of June 2012, not to instruct an expert to prepare a report, a forensic audit of the Horizon system, hadn't it?
The decision had been made to go, in my head, to go with Second Sight for the right reasons.
The note records what will it achieve, and I'm not going to attribute any of these words to anyone, because when he gave evidence, Mr. Morgan took the point that it's not clear that it's him speaking
Right.
Here, and it doesn't necessarily represent his advice. It could be anyone speaking. What will it achieve? It will not be able to address any of the civil or criminal cases dealt with under old Horizon. Was that advice communicated back to you, that an independent report couldn't look at civil or criminal cases dealt with under Old Horizon?
No.
Will it seek to review particular cases? If so, which ones? And then what might be said to be the important paragraph is the third one. Whatever the findings of the expert report, it will not resolve the problem. The Post Office will be damned if they do and damned if they don't. If the findings are that there are no issues with Horizon, people will see that as a whitewash. And then this, whereas if the findings are negative, that will open the floodgates to damages claims by sub-postmasters who were imprisoned for false accounting. And Access Legal, that's part of Shoesmiths, will start to pursue the civil cases they're currently sitting on. Was that view communicated back to you as relevant to decision making if we commission an independent report which comes back with negative conclusions, people who have been imprisoned might bring claims against us?
No, absolutely not.
And that would be a reason not to commission an independent report, because it might find out things that entitle people to question their convictions or bring damages claims against us.
No, I didn't know about this.
Did that ever form part of your decision making? We best not ask for the Deloitte report, because if it discovers too much, we may face damages claims.
No.
To your knowledge, did that ever form part of any discussion or decision making at board level?
No. And as I say, in the meeting where we took the decision to go with Second Sight, I don't remember looking at two separate sets of documents and comparing and contrasting.
And the foot of the screen that's being displayed, a less risky approach is to agree to take the relevant MPs privately through particular cases in which they are interested. Was that ever communicated back to you?
No.
Thank you. Can we return to where we were in the chronology, which is the following year, June 2023, by looking at poll 309 8789. And if we scroll down and look at the text, the message from Olwyn Lyons, it's dated the 28th of June 2013. We're getting quite close here to the date of the production of the Second Sight interim report, aren't we?
Yes.
Which we know was published on the 8th of July 2013. Yeah. It's quite difficult because the way the text has been printed on this email. But if you look at the fourth bullet point, Miss Lyons says to you that she is going to spend time with Janet. Is that Janet Walker?
Yes.
And remind us who Janet Walker was.
Janet Walker was the executive assistant for Lord Arbuthnot.
She says she can give me as long as it takes. My approach will be to try to get to understand the status of the review and the risk to Lord Arbuthnot and us of an incomplete interim report. I'll share the fact that Second Sight are not using all the evidence they've been given, and our concern is that their approach to try and keep everyone happy is not how we would expect a forensic accountant to behave. I do think this is the right place to share the bugs we found and how we have dealt with them, which is why the report from Rod/Leslie, checked by Legal and Mark, is important. My objective is to get Janet to a place where she also wants the meeting to be cancelled. And then if we scroll up, please, we'll see your reply. Sending on to Alice Perkins. The second paragraph, you'll see below Alice's, Olwyn's proposed next steps, covers all the ground. Olwyn and I, third paragraph, are staying close, and I'm expecting an update later this afternoon. No need to bother you today. On what basis did you understand the Post Office had determined that Second Sight were not using all of the evidence that the Post Office had given them?
From conversations with the team involved in the work.
Second Sight were getting it wrong. They were
No, I don't
not
think...
looking
I
at the
beg your
evidence.
pardon. No, I'm sorry, I didn't mean to cut across you. No, I don't think that is what I was told. What I was told is that they hadn't, because this had run on too long, they hadn't yet had time to take account of the Post Office's view in the investigations they were doing. That's my recollection of what I was told, not because they were getting it wrong.
But was there any...
Sorry, I beg your pardon. They may have been getting it wrong because they hadn't yet taken account of the input from the Post Office.
Was there a suggestion in what you were told that Second Sight were biased in their approach?
No, certainly not at this stage. My very clear recollection is this was simply, to describe it more colloquially, the team felt it was unfair because Post Office hadn't had the opportunity to contribute yet. Whether that was true or not, I didn't check that with Second Sight, but what I was told is that the work was so far behind that Second Sight had yet to take account of the Post Office's input.
Was the sense of unfairness conveyed to you?
Frustration, I think.
By who?
Olwyn certainly was one of the main people I spoke to, Susan, and I think David Oliver, but I'm only remembered by having seen his name today.
What evidence were you told that the Post Office had provided to Second Sight that they were not using or taking account of?
I can't remember today, I'm sorry. They were looking at a number of they were looking at a number of cases, is my understanding, and these cases raised different issues. So it would have been whatever data the Post Office needed to present about the issue that was being investigated.
Were you told that Second Sight were trying to, in the words of the email, keep everyone happy?
I was told that, and I knew, I think, because we had agreed to fund K-L to support the JFSA, I was told that they, I think, if I remember the timing correctly, that they had been asked by Lord Arbuthnot to keep the JFSA happy. And I don't think we had any problem with that until the team began to raise these questions that perhaps because of that Second Sight we're not looking at the Post Office work. But I'm probably now speculating too much, to be fair.
Did you tell Second Sight that they were being unfair on the Post Office by not taking account of the evidence that the Post Office was giving to them?
I didn't have regular conversations with Second Sight. I was running the organisation. I wasn't closely involved in the detail of this work. I'm not sure if I spoke to him at this time, but I would have had no problem sharing that piece of information.
Did you tell Second Sight about the Post Office's concerns about its approach, or alleged approach, of keeping the JFSA happy?
I don't believe I spoke to Second Sight.
Did anyone, to your knowledge, say, you're not treating us fairly, you're trying to keep the sub-postmasters happy, and you're not looking at our evidence?
I would hope that the Post Office team... Sorry, first of all, I don't think the Post Office team would have said you're trying to keep the sub-postmasters happy. I may be wrong on that because that feels too strong a view in one direction. This whole point was to look at the sub-postmasters' cases. But I think the team would undoubtedly have said to Second Sight, there is more information here to be taken account of.
Can we look a little more deeply at the move to select a small number of cases by looking at poll 0014-4687? This is the previous month. If we look at page 2, please. And scroll down. An email between Simon Baker and Second Sight, with Alwyn Lyons copied in. Not you at this stage, but it's about a meeting. I think this is the meeting that we've just seen Post Office was going to try and get cancelled.
Right.
Ron, just to ensure that we're on the same page, Paula would like to say we've agreed the following with Second Sight. Can you confirm you agree? The investigation reports on 2 to 3 EMPs cases by summer assess or more. By using the 2 to 3 cases, you'll answer the question, have systemic defects in the Horizon system resulted in the wrongful conviction or suspension of sub-postmasters? By this stage, had the proposal that we saw at the first thing this morning to examine a representative sample of cases been abandoned?
Not on my understanding.
How did it come about that by late May, the Post Office was proposing that by looking at 2 to 3 cases, Second Sight could answer the very big question, have systemic defects in the Horizon resulted in the wrongful conviction or suspension of sub-postmasters?
I'm not sure, but when the report was produced, as the inquiry knows, one of the conclusions was that so far no systemic defects had been found. So whether as a result of the broader work, so Second Sight had been working...
Sorry, can you repeat that answer, please?
Yes. When the Second Sight interim report was published, one of its initial conclusions was that so far no systemic issues had been found with the Horizon system.
And just stopping there,
Yeah.
that's 2 months after this.
Yes, but I'm getting to
I'm-
answer your question,
Yes.
if I may, because to have reached that conclusion, which in a sense is what point 4 here refers to, referring back to point 2, you couldn't reach that conclusion on 2 to 3 cases. So how could you do it on 2 to 3 cases? Because of the other work they had done. They were working through different themes, as I understood it, so potentially through that work. Second Sight had been working on this for 10 months now. They hadn't just done they hadn't even done 2 to 3 cases in that period of time.
Why was the proposal to limit the report to determining whether systemic defects in Horizon had resulted in wrongful convictions on the basis of 2 or 3 cases?
I don't know. I wasn't involved in the conversation. I believe from other documentation I've seen that the recommendation was to choose 2 of the 3, I don't think this is the word, but hardest cases. So not cases that would have presented the Post Office in the best light, but cases which could have been used to challenge the Horizon system and then do that work through. There is some documentation on this somewhere else.
How could 2 or 3 cases possibly answer the question, have systemic defects in Horizon generally resulted in the wrongful conviction?
They couldn't. They could not possibly do that. And I wasn't involved in this conversation, but by this stage, there was an urgency to have a report produced that showed that some work was at least in progress. And
You say you weren't involved in this conversation. This email says you want to say this. Paula would like to say the following.
Yes.
Did you want to say that by looking at 2 or 3 cases, we can answer the entire question of whether systemic defects had resulted in the wrongful conviction of sub-postmasters?
I was absolutely not, to be completely clear, trying to drive a conclusion from Second Sight that they would not have given.
It's an answer to a different question.
No, I realise that, but I don't recall the background. So I didn't write this email. I wasn't copied in this email. I don't recall a conversation where I consciously said it would be possible, because it wouldn't be possible, to come to a conclusion on systemic defects as a result of 2 to 3 cases.
Isn't that exactly what happened, Ms Vennells? That the Second Sight report addressed a very small number of cases. It contained the sentence about no systemic defects, and then forever after, the Post Office paraded that conclusion.
It did come to that conclusion in its interim report. There is no way the Post Office, first of all, there is no way that I would have wanted to persuade Second Sight on something that they were not prepared to say, and I don't believe Second Sight would ever have agreed to that. If they came to that conclusion in their interim report, that was their conclusion.
Isn't that what the Post Office wanted to drive them to? And isn't this the evidence of such driving?
The Post Office most certainly wanted the reassurance that the Horizon system could be relied upon. That has been the objective all the way through this. At no stage did I get the sense that anybody in the Post Office was going to be able to influence Second Sight over what conclusions they came to. I would be very surprised if that was the case here.
Did you receive, or the board receive, any advice as to the appropriate scope of an investigation by Second Sight, as to the nature and extent of any investigation that would be required in order to determine whether there were systemic defects in Horizon?
The only information I and the board had was contained in the terms of reference of the work that Second Sight were doing, which is what we looked at earlier.
I.e., we, the Post Office, need to engage somebody to produce a report whose conclusions are respectable and truly provide us with the answer as to whether or not there are systemic defects in Horizon.
Yes.
You think that's the report they produced?
Second Sight didn't produce the report that Project Spire under Deloitte could have produced. Second Sight responded to the terms of reference which were agreed with them. This work was approached from the point of view of trying to resolve postmaster cases. That was the genesis of it. That was the initial conversation with Lord Arbuthnot and Alice Perkins.
Can we move forwards, please?
Before we do, Mr. Baker, can I just be clear about what you are saying about this email, Ms. Vennells? As I read it, it is a request by Mr. Baker to Mr. Warmington that 4 matters are agreed, and it reads as if he is making that request on your behalf. All right? That's how
Yes,
it reads.
It does read that way.
So what is your evidence to me about whether Mr. Baker was accurately representing what you had told him in this email?
Firstly, Sue, and I don't recall the conversation with Simon Baker
Right.
at all. I rarely met with Simon, and if I did, it was usually with Susan or Alwyn. But it sounds as though at some stage a conversation was had, and I may have accepted that you could. This email could have been produced one of 2 ways, couldn't it? Or multiple ways. I could have said, this is what I want, Or he could have said to me, this is where we're at. We think that actually we will get 2 to 3 MP cases done. And I may well have said, will that help us to answer the question about are there systemic defects in the Horizon system? I wouldn't have known personally from any of the, because I wasn't involved in the work or conversations at Second Sight, point 4 about whether they could have said no or not at this stage. So I can only assume that has come from a conversation with Simon Baker and or somebody else.
All right.
Thank you. Can we move forward a couple of days to poll 309-8317? This is a briefing for you for the meeting that was proposed to be held between you and James Arbuthnot on the 23rd of May. Can you see that?
Yes, yes.
And it says, under key messages, we're concerned that the investigation's overrunning, the findings will not be definitive, and there'll be no satisfactory outcome to the Horizon question for MPs or the Post Office. We would like to discuss ways to more clearly define the scope so we get a definitive outcome within reasonable timescales. And then under the heading background, 2.1, when the Post Office commissioned Second Sight, the expectation was that the investigation would review a small number of MP cases, 6 to 12 cases. Firstly, does that represent your recollection of the Post Office's expectation when Second Sight were being instructed?
I don't remember today, but we were talking to Lord Arbuthnot and I think 2 or 3 other MPs, so that's entirely possible.
Do you know why it was the Post Office's expectation that a smallish number of cases, 6 to 12, would be the limit of Second Sight's review?
Presumably because that was the number that was being discussed at the time.
Discussed by who?
With James Arbuthnot and the team working on it. I don't recollect 6 to 12 cases as a particular number, because what I remember is that the number increased as more MPs raised cases.
You remember the Second Sight proposal that we looked at? Its suggested scope of work
Yes.
was to review a representative sample of cases in order to answer the question of whether there had been wrongful convictions.
Yes.
Was that the Post Office's understanding when it was commissioning Second Sight, that that's the work that it would be undertaking?
If that is what was in the final terms of reference, yes.
The speaking note or briefing carries on. MPs have now submitted 29 cases and JFSA have submitted about 20 cases. It's unlikely that the investigation, no matter how long it runs, will conclude anything definitive. As the remit has become blurred, different stakeholders have different expectations and the evidence is open to interpretation. Was that a view that you held at the time?
I didn't have a view on the work because I wasn't closely associated with it. So I would take the view that I was given by the experts who were doing the work at the time.
So you would subscribe to or be willing to repeat that view expressed in 2.3?
Not necessarily. I mean, if I was given information, I would usually ask questions about it. I don't know what I did with this brief at the time.
The suggestion that any investigation would conclude anything definitive, was that your understanding?
No, I don't think that was my understanding at any time throughout this, and the inquiry will see there is further documentation where I'm exhorting the Post Office and Second Sight to move through the cases because I wanted the cases looked at. There was at this time, actually, as a potential helpful issue, a number of cases had come through, I think, from MPs, and there was some debate about whether there was sufficient information and quality of information to be able to do any work on them at all. And that was Second Sight's view. They went back to some of those cases, and in some cases they couldn't produce information. So whether that was part of this point, I don't know.
Did the Post Office subsequently present Second Sight's interim report as a definitive view that there were no systemic errors or failures in Horizon?
The Post Office presented it sometimes definitively and sometimes less so, yes.
Do you know how that came about, given what is recognised by this note at this stage?
No, I think what happened is that when the interim report was published and it said it was an interim report and so far it had found no systemic issues with Horizon, that was reported sometimes in communications saying so far they had found none. Mm-hmm. And there is documentation where I'm asked about, or maybe I offered the view that actually the qualification was so far. And there are other communications which may simply be inconsistency of communication, I don't know, which simply says they had found nothing systemic.
Under the heading, just above the heading, Proposal 2.6, the investigation's been running for a year, and to date, no evidence of systemic failures has been found. Proposal, James Arbuthnot to request Second Sight to complete the investigations on 2 to 3 MPs' cases, selecting the ones they feel best indicate systemic problems.
That was the point I was trying to make earlier, thank you.
How would an individual case indicate systemic problems?
I don't know that I can answer that question. It couldn't, could it?
Bit tricky, isn't it?
It's very tricky, yes.
This was a briefing to you of what you should say and seek to achieve in a meeting with James Arbuthnot. Yes?
Yes.
Had you signed up to this idea by this time, at least then, that James Arbuthnot should be asked to persuade Second Sight to wind their investigation up on 2 to 3 cases, and those 2 to 3 cases would answer the question, have systemic defects resulted in the wrongful conviction of sub-postmasters?
Could you ask the question again?
Yes.
I'm sorry.
Had by this stage,
yes,
in readiness for the meeting with James Arbuthnot on the 23rd of May 2013, you signed up to the idea that he would be asked to persuade Second Sight or request Second Sight to wind their investigation up on the basis of 2 to 3 MP cases answering the question, have systemic defects in Horizon resulted in the wrongful conviction of sub-postmasters?
I don't believe so, because we had committed to a larger number of cases. There were significantly more cases now in, I was going to say the scheme, but we're not yet into the scheme, but now in the project. This was an interim report, and I don't think there is any evidence that I thought that was the case. My understanding was that we had made a commitment to the MPs, and all the way through this, I wanted all of the cases looked at.
We've seen now an email that attributes to you a suggestion that you wanted to agree this with James Arbuthnot, and a speaking note or a briefing note saying the same thing.
It doesn't say that I'm trying to wind the scheme up, which I think was your question.
Okay, they should focus on answering the question, have systemic defects in Horizon resulted in the wrongful conviction of sub-postmasters by reference to 2 to 3 cases?
Yeah, so
Was that your view as to what should happen?
no, at no stage did I make the link that you have just led me to make between these 2 to 3 cases and being able to reach a view on the system and being able to complete the whole piece of work. What I was very aware of is that this was an interim review coming up, and that there were more cases to go through the scheme.
The link is made right here in this document, isn't it, in paragraphs 3.1 and 3.2?
It is, and as I mentioned earlier, before the document came up, my understanding was that from the work Second Sight had done, presumably around the thematic work where they had been looking at a number of cases, and they're now being asked to take 2 or 3 cases which may or may not show whether sub-postmasters had been wrongfully convicted.
Can we move forward?
I was not trying to close anything down. It's really important that I say that.
Can we move forwards, please, to closer to the production of the interim report? Poll 3099003. An email from Martin Edwards. Can you explain who Mr. Edwards was at this time, July 13?
Martin Edwards was my chief of staff.
He emails you on the 4th of July with a draft for the board. He says, hopefully it's not too long, but it's difficult not to open some of these issues without providing a reasonably full explanation. And so what follows is this, right, a draft email that you were to send to your board.
Right.
Is that right?
Yes.
Okay. And then beneath the dotted line, we see the draft email. I wanted to send you a brief email to update you on where we are with the Second Sight investigation. We've been engaging closely with Second Sight throughout the week to understand the position they intend to take in the interim report and emphasising our concern that their findings must be even-handed and grounded in the facts. In line with our discussion on Monday's board call, we understand they've not found any evidence yet of systemic issues with the Horizon system, and it should be noted that this is based on a detailed review of their 4 best cases in terms of compelling evidence. So by this time, I think you had drawn a link between a review of a small number of cases, it's got up to 4, and whether there were systemic issues with Horizon.
Yes, but I hadn't drawn that link. That, I think the way I read this is that is what the team had understood from Second Sight.
What Second Sight were prepared to say that there were no systemic issues with Horizon generally on the basis of looking at four cases.
That appears to be the case, but as I've said, they also were doing wider work by this stage.
What was your understanding at this point at what systemic issues meant?
I'm not sure, as I say in my statement, that I was able to make an informed decision on that. Second Sight themselves, I think, refer to it as something that might have a broad impact across the post offices or across the system. I can't remember, but you will have the reference.
Was there a shared...
And so my assumption, if they felt they could reach this conclusion from a small number of cases, was that perhaps, but this is my reflection today, I don't think I had the reflection at the time, was that perhaps they had seen something in those cases that could have occurred elsewhere. But I'm speculating to try and help answer the question that I didn't ask at the time.
Was there a shared understanding between you and the Post Office Board as to what systemic issues meant?
I don't think the conversation ever happened.
Was there a shared understanding between you and the Post Office team that were leading on the work with Second Sight
No.
as
No.
to what systemic issues meant?
No.
Was there any discussion over what systemic issues meant?
I don't recall one, no.
Thank you. So it's 11 o'clock. May we take the morning break until 15:15?
Yeah.
Thank you. Ms Vennells, can we turn, please, to some documents that may provide some insight into your approach and decision-making in relation to the Post Office's decision not to review all past convictions in the light of what was emerging from Second Sight? Can we look, please, at poll 309-9056? And if we look at the bottom of page 1, please. And if we just look at the top of the page, I think we'll see who this is sent to. Leslie Sewell, Martin Edwards, Mark Davis, Alwyn Lyons, Susan Crichton. Mm-hmm. Go back to the bottom of page 1, please. Thanks for your inputs today. Susan, I need your thoughts on the note below, especially 1 and 2, please, and the questions at the end of the mail. I think we have the following, which is a variant. 1, a working party over the next 3 to 4 months. This comprises the Post Office working collaboratively with the JFSA and does 3 things. So just stopping where we are at the moment, I think you knew, is this right, of the likely content and conclusions of the interim report. This is 2 days before it was published, and you're now working out the next steps.
I think that's right, yes.
The working party firstly explores the Second Sight 8 themes for improvement. Can we get less than 8? And agrees how they can be implemented. Secondly, looks at the remaining past cases with the JFSA and MPs if they wish, to see if further themes or new evidence emerge. And then this. Thirdly, our external lawyers review all prosecutions in the past 12 to 18 months since the Post Office has been independent of Royal Mail in the light of the Second Sight findings. The JFSA Post Office Working Group reviews the findings, and then in square brackets, why would they not review all cases of false accounting, e.g. over the last 5 to 10 years, especially where amounts have been small? I assume large amounts would be less likely to get away with saying they were muddle-headed and not helped. But could we review all? It's the false accounting charge that James Arbuthnot was most concerned about. And then if we scroll on, please, over the page. I'm going to skip over 2 and 3 for the moment and look at 4. Issuing a statement that although the system has been proved to have no systemic issues, and our training support processes and helplines have worked for most of the 50 to 60,000 colleagues over the past decade, we're nonetheless genuinely sorry that some of our sub-postmasters who were struggling did not feel we offered them sufficient help and support when they needed it. We're grateful to the JFSA and James Arbuthnot for highlighting the issues. Many are historic and already improved, but we're always open to new ways to improve how we do business to ensure the Post Office stays as trusted and effective in its communities as it ever was. So going back, and sorry, you say, can we draft this into something I could send to Alan Bates? Yes?
Yes, yes.
Last paragraph. Susan, would we ever ask the lawyers to consider reviewing past prosecutions? Is that what we're talking about in 1 above, but simply not using the terms? If not, why would it be different? Of our 500 prosecutions, how many are for false accounting? For clarity, these are open questions, just want to know the answers, not an indication that I want us to do so. So just going back to the first page, please, at the foot. The point 3, our lawyers, external lawyers, reviewing all prosecutions in the past 12 to 18 months. And then you ask the question, why would the external lawyers not review all cases of false accounting over the last 5 to 10 years? Why was the proposed review to be limited to prosecutions in the last 12 to 18 months?
I don't remember, and if I might just add, in case there's any confusion, the description muddle-headed was one that Mr. Bates had used. That wasn't a word, and I had picked that up. But in terms of answering your question specifically, I can't recall why 12 to 18 months. There was a question raised by the board at some stage as to...
These are your proposals, though?
No, I think this is... I believe this is me pulling together a number of suggestions that had come in over a period of time from different colleagues.
And you have drawn them together.
I've tried
and
to...
said, we've got the following, which is a variant. And you've said, can this be drawn up into a document that can be sent to Alan Bates?
Yes, and what I'm doing here, I think, is showing with colleagues, the way that I worked and they worked in an iterative process, is have I understood what, does this seem a sensible way forwards?
And so you were going to propose that the lawyers review all prosecutions in the past 12 to 18 months?
No, I wasn't proposing that. I had been given that information, I think, by somebody else.
Okay, who had given you the information?
It could only have been Susan.
Why were they proposing the past 12 to 18 months?
That I'm not sure. And what I was just trying to say is that the board had asked at some stage, but I'm not sure if it was at this point, whether the company, and this is also a nice Perkins statement, had conducted any prosecutions which had relied solely on Horizon, because there was a concern, clearly, because of the issues that were being raised by Lord Arbuthnot, that the board didn't want to be taking prosecutions until the various investigations had been seen through. But I don't know whether that was anything to do with this particular point. The person, if I have collated this from information from colleagues, that could only have come from Susan, I think.
You drew this up as a collection of what had been said to you,
yes,
or passed to you, and you were happy to put it forward as a proposal subject to the questions that you asked.
Yes, I think we were trying to find a way through post the interim report. The interim report was about to be published, and we still had numbers of cases that needed to be reviewed, and we were trying to find... and what actually happens is this is moved on a couple more stages, was a solution that would get us through the other cases that would work for the JFSA.
So what was the logic of the proposal to review prosecutions in the past 12 to 18 months?
I'm afraid I can't remember, and I can see that I'm asking, in a sense, I don't put it that clearly, but I'm saying, why would they not review all the cases?
It says review all prosecutions in the past 12 to 18 months since the Post Office has been independent of Royal Mail. Was that seen in your discussions with the people involved as the important point of distinction? Will only go back to the point of separation, i.e. April 2012?
No, I think that is my point about the question that was raised in the board, because the board had only been in place since the Post Office had been independent of Royal Mail.
You ask in brackets, why would they, the external lawyers, not review all cases, e.g. over the last 5 to 10 years? Why were you asking that?
I assume because that seemed a fairly sensible question, which is why would we be restricting ourselves to a particular time period?
That's logical, isn't it?
If we're trying to do this properly, why wouldn't we do all of them? Yes.
If we're doing this properly and fairly, why wouldn't we look back at all cases of false accounting?
Yes.
Was that done?
The scheme, no, in terms of what we know today, clearly not. The scheme was opened to 150 cases that came forwards, and the Post Office advertised across the network for any postmasters who wanted to come into the scheme and have their cases reviewed. So my understanding at the time is that we were open to however many postmasters came forwards. But in terms of specifically the Post Office legal team and its lawyers, going back and looking at all the cases, that wasn't the work that was in place.
Why wasn't it put in place? Here you're suggesting that the Post Office itself, through external lawyers, proactively review all cases of false accounting going back up to a decade.
Yes.
And you've, I think, accepted that that would be the fair and proper thing to do. Why didn't the proper and fair thing to do get done?
I can't remember whether you have any further documentation that would see what answer I got to that.
We're going to come to the answers,
yes,
the narrow answers, and essentially we're going to find out that Mark Davis, the PR guy, said it's very dangerous.
I don't remember that. I was asking the question to do this work the right way, and my understanding and acceptance of what was proposed, which was accepted by the MPs and everybody else involved, was that the mediation scheme was the right way through. I think we see other documentation that sees cases go to the CCRC. There is documentation that says cases can't be resolved through mediation in the scheme and they would need to go through the Court of Appeal. The fact I can recall those, I suspect there was a wider discussion around this at some stage.
Do you agree that your nascent idea here of a review of all prosecutions of false accounting, if it had been carried into effect, may have avoided a lost decade until miscarriages of justice were discovered?
It may well have done. It may well have done.
Do you think the failure to carry into effect the idea that you posit here was a missed opportunity?
At the time, I and the board and everybody else involved in what succeeded after this particular point, what took place after this particular point, felt that that was completely the right way to do this. We were concentrating on individual cases.
You say that such a review, especially where cases have been small, because large amounts would be less likely to get away with saying they were muddle-headed. What do you mean by that?
I'm not entirely sure now. You can see from the way these questions are asked that I'm operating in an area of business, the legal sphere, that I, at the time especially, was very naive about and didn't understand. So I am asking questions because one of the roles of a chief executive is to not sit on questions, is to not stay quiet on things that you don't understand. Sometimes you ask questions and they sound stupid, but it's the right thing to do because you need to ask those questions. And I'm not entirely sure here whether I was assuming that large amounts of false accounting might point more to crime than not. I don't know.
Can you help us as to why you would come up with that idea? A person accused of false accounting in relation to a small amount of money may be more likely to deserve or need a review of their conviction versus a person accused of false accounting a large amount of money?
I don't think that's what I'm saying. I think what I'm saying is that so first of all, I'm asking questions and I don't understand this. I think what I was asking is that if somebody had committed false accounting over a long period of time and had therefore reached a large sum, and I realise today, and I regret what I've said, that I understand very much today why sub-postmasters were driven to do this, but at the time, my naive assumption was that if somebody was false accounting on a regular basis over a long period of time and accumulated a large amount false accounted, that might give an intention of something that was perhaps more planned than where an amount might have been an occasional example.
Okay, can we look at Mr. Davis's reply? Poll 30999055. Foot of the page. Hi, Paula, could we have a word at some point today to discuss this, and specifically how far we go in terms of the wording below? I'm sending this just to you at this stage. I'm very concerned that we may get to a position where we go so far in our commitments that we actually fuel the story and turn it into something bigger than it is. I'm not at all complacent about the issues, but there is a real danger in going too far in commitments about past cases. This is for two reasons. First, the substance of the report doesn't justify this response. Indeed, the response is at such a level that our current media strategy would mean there would be some coverage, but not very much. If we say publicly that we'll look at past cases, whether from recent history or going further back, we will open this up very significantly into front page news. In media terms, it becomes mainstream, very high profile. It would also give James Arbuthnot a very strong case for asking for a parliamentary statement from BIS. My second concern is the impact this would have more broadly. It would have the ballistic impact which AB fears. It would lead to a very public narrative about the very nature of the business, raising questions about Horizon. The reality of what Second Sight has found would be misunderstood, and having an impact on public views about the post office and really widening the issue to the whole network. Do you agree that Mr. Davis is here giving you personal advice on the extent to which past convictions are reviewed on the basis of the extent of the media coverage that each decision might generate?
My understanding at the time was that he, and I think the Post Office generally, and we've seen similar comments from the chairman as well, believed we were dealing with a small number of cases, and the numbers that were coming forward seemed to, at that stage, clearly more came later, seemed to indicate that was the case. And the inquiry heard from Mark Davis last week, I think, where he explained, and that was my understanding at the time, that what he was trying to do was to minimize misinterpretation. It was wrong, because clearly if all past cases needed investigating, they needed investigating. But at the time, that wasn't what the Post Office thought. And I think what he was trying to do here was to, as I say, to minimize misinterpretation and exaggeration in the media.
Do you agree that his first point says you should make a decision about the extent to which you review possible past miscarriages of justice by reference to the extent of media coverage that it will generate.
It does say, it could be read that way. That wasn't my...
Is there another way of reading it?
That I wouldn't have...
And if there is, please explain which words help to read it in a different way. He's saying don't go back 10 years or say that you'll go back 10 years. Our current approach would mean there's going to be some coverage, but not very much, the usual suspects. If we say we'll look back at past cases, we'll be on the front page. Isn't he directly saying?
Yes, I can see that that's what he's saying, but my mindset at the time when I received this is that we were working on specific cases that were coming forwards, and we opened up...
No, hold on, Ms. Vennells. The email that you had sent, to which this is a response, posits, should we look back 12 to 18 months since separation?
Yes.
Or should we go back further? Why aren't we going back
Yeah.
further, 5 to 10
Yeah.
years? And this says, you can't do that. You'll be on the front page. That's a grossly improper perspective, isn't it?
Yes, it is. Yes, it is.
Do you know why he cut everyone else out of the chain and replied directly to you?
No, I don't.
Was he a very trusted advisor?
He was trusted by all of the team. As I said yesterday, I trusted all of the team, none of them more than the others.
Did you remain in contact with Mr. Davis after you left post office?
I did.
Did you exchange messages with him about media statements that you might make and the media lines that you might take in the announcement of this inquiry, for example?
I believe the inquiry has texts that show that.
Even though you'd moved on, he was still advising you into 2020 as the lines to take in your media statements?
I had kept in touch with Mr. Davis for reasons that were very personal to him, and I think he offered that advice at the time.
To what extent did what Mr. Davis advise here affect your decision making?
I would never, it was simply not the way I worked, have taken a decision based on the advice of one colleague. Never. My way of working was to take as many different views as I possibly could and to involve those individuals in the decision making as much as I possibly could.
Can we look at the top of page 1, please? Your reply. Mark, thanks for this. I don't think we're too far apart. I didn't say this approach would be our media statement, but they'd need to be aligned. You're right to call this out. I will take your steer. You did take the advice of the PR guy, didn't you?
I really don't remember it relating to the decision.
Hang on now, please. Thank you.
As I tried to say before, what we were working to at this stage was numbers of cases going through a scheme, and a scheme that was going to be opened up to anybody who wanted to come forwards. I understand how this reads, but I don't recall making any conscious decision not to go back and put in place a review of all past criminal cases. My conviction as we were going forwards in this was that this scheme would enable any case that any postmaster that wanted their case to be reviewed, that the scheme would allow for that.
You continue. There are two objectives, the most urgent being to manage the media. The second is to make sure we do address the concerns of James Arbuthnot and Alan Bates, mainly looking forwards. But we should be aware of Alan Bates' driver is really justice for the past. Otherwise, they will call for reopening cases.
Yes.
It may be that we get to manage Alan Bates and James Arbuthnot by playing on the go ballistic view, i.e. I'll meet him privately to hear his views about these cases, but we cannot refer to anything in relation to past convictions. Any challenge must go via normal legal routes. Is that the way your mind worked at this time? The priority was to manage the media and then deal with the actual substance of issues?
The media issue related to, I believe, because we were right on the day or the day before the release of the Second Sight interim report. And that's my recollection, that is the media conversation that we were having.
But what we're talking about here is how far back a review of possible miscarriages of justice should go.
Yes, and I'm not closing that down at all.
You say there are two objectives, the most urgent being to manage the media.
I'm pretty sure that was in relation to the interim report, which was due out any time, which, as the inquiry has seen and heard from other people, there were issues in that report which the Post Office disagreed with and the team felt Second Sight hadn't taken account of. That, I think, was the issue that we were talking. So this was a really urgent today or tomorrow issue. And then there was the concerns looking forwards.
No, what you're saying here is you're right, Mark. We will put the past behind us. We won't look at past cases. We'll focus on the future.
That isn't what happened. That simply isn't the case, because the scheme was open to past cases. There was no time limit.
The burden was put on the sub-postmaster to prove their case, wasn't it?
The scheme was open to any postmaster who wanted to bring their case forwards. It was advertised in various ways to encourage people to come forwards. There were other conversations going on at the same time as this exchange with colleagues, and it was very clear that any cases that included criminal convictions would need to go through the Court of Appeal and the normal legal routes. I don't think I understood any more about the legal side of things to have got involved in anything more complex than that. I believed very sincerely that the scheme we were putting in place would help.
Do you accept that this exchange of emails shows that in making decisions as to the substance as to what the Post Office should do, i.e. whether it itself should seek to review whether there had been past miscarriages of justice, you took into account the views of your media advisor as to the extent to which your decision would meet with front page news?
I do not recall that being. I see what is written here. There were other conversations going on at the same time. The highlighted paragraph isn't as clear as what you're saying. I do not think, and I would not have taken personally any decision on review of historic cases. That was not my role. I wasn't qualified or competent to do that. I did not take that decision. What I was trying to do at this stage was to find a way forwards through the cases that had come into the Post Office, and to encourage more to come forwards, which would have enabled any case to go through normal legal routes if the post office couldn't help it.
What did
So
you...
no, I absolutely don't accept that I took a decision to not review past criminal cases based on a media outcome. I didn't take any decision on that. I wouldn't have been able to do so. And it would have been such an important decision that would have had to have gone to the board.
Can I just ask, and this may be entirely my fault, so I preface it by that, but I'm not clear that as of the 6th of July or the 7th of July or this period of time, this discussion of how to approach the issue of past cases is taking place in the context of Second Sight continuing its investigative work beyond the interim report, or in the context of the idea of a mediation scheme. Do you understand the distinction I'm trying to draw?
Not entirely. Would you?
Well, as I see it in simple terms, Second Sight began by investigating in the context of a number of cases.
Yes.
And after their interim report, somehow a transition took place so that what I'll call a mediation scheme emerged. And I'm not sure, as of this date, i.e. at or about the time when Second Sight was to produce its interim report, whether the discussions of how to deal with past cases was in the context simply of Second Sight moving forward with their investigations, or by that stage, in the post office's mind, that was at an end and something new was emerging.
No, I think that's a helpful question. I think there was a process of evolution. So second...
Sure, but I wanted to try and
yes, and
pinpoint...
I'm trying to think through what...
Yeah.
Second Sight had done the work it had done up to the publication of the interim report. There was still a number of cases that hadn't been looked at, which needed to be continued. I had been disappointed about the way the post office team hadn't worked as well or been able to contribute to the work Second Sight had done. And I say that I would like us to work collaboratively with the JFSA, who still had a very serious vested interest in that. And a proposal was made to form a working party, I think was the word that was used. And that was, I recollect, an attempt to work together to go through the remaining cases. At some stage, and as we were going through this, because it was an iterative process, people were contributing ideas as to how this might play out. I had a conversation with Susan, and this I remember very clearly because I can remember where it was. I'd arrived home at this, and I was standing on the station, and she called me, and Susan suggested that a way of bringing... The trouble is I now know what didn't happen, but some of these cases, or these cases to a conclusion, would be to introduce mediation. What she said was that, and again this is in documentation somewhere, is that mediation, that sometimes what was needed in cases is for people to hear the post office apologise and say that it was sorry that it got things wrong, or for the post office to explain to a sub-postmaster that perhaps they had done something wrong, and that once the cases had been reviewed through this working party process, that might then be a way to reach some finality on those cases. What was also talked about at the same time was that if this was a good thing to do, which clearly it was, the post office then needed an ongoing process, possibly an adjudication process, an external ombudsman, on a permanent basis, so that if this type of challenge arose again, there was an external appeal process, if you like, for sub-postmasters to go to. And the thing that I'm missing, Sir Wynne, in telling you all of that is if Susan knew, which of course she did and I wouldn't have known so well, that criminal cases couldn't be resolved through mediation. And this is simply a question, did she know that there would need to have been a further review, or was her understanding at that time, which is a fact that was later described, that any criminal cases going through the mediation scheme would be open to all of the investigation work that was done by Post Office and Second Sight and Fujitsu, which may then give them information to take forward through the normal legal routes, through the Court of Appeal or the CCRC.
Ms. Vennells, can we look at page 2 of this document and scroll down? This is your thoughts on the proposal as at the 6th of July.
Yeah.
In direct answer to the chairman's question, isn't it the case that Second Sight were to play no part going forwards?
There were conversations about whether Second Sight should or shouldn't, because there were concerns about the fact that this had run on too long and was way over budget, and there were, and this again is in many documents, there were concerns that their work was not at this stage sufficiently evidence-based.
Your proposal didn't involve any role for Second Sight, did it?
I'm not sure that's
Look at the
true.
email
It
on
was
the
a
screen.
consideration. Sorry?
Look at the email on the screen. Your written proposal did not contain any role for Second Sight, did it?
It doesn't at this stage, because we're in this process of evolution, say that Second Sight...
This process of evolution, it doesn't involve any role for Second Sight.
I'm not sure, because I'm not. It doesn't say that they would or they wouldn't. What it says is that it would explore their themes for improvement. And I'm being frank with you that there were conversations about whether that there was criticism of the work that Second Sight had done, but there was equal understanding that they had the support of MPs, notably James Arbuthnot, and that we had committed to do that work. But
Back to page 1, please. You say you're right to call this out. I'll take your steer, no issue. Do you agree that this email chain reads as if the PR man has influenced you conclusively as to a decision as to whether or not the Post Office would itself review whether and to what extent there had been past miscarriages of justice?
I wouldn't take that steer on a legal matter from Mark Davis. He clearly... He was talking about... And again, in the timescales we're talking about publicity within the next couple of days as a report coming out. But I wouldn't have taken a decision on anything at all to do with legal matters from Mark Davis.
Okay, let's see what the... I'm so sorry, I spoke over you.
Sorry, it's fine.
Let's see what the IT person was telling you on what to do about looking at possible miscarriages of justice. Poll 3009-9056. This is a separate chain, remembering that Mark Davis had just replied to you. This is Leslie Sewell's reply to your email setting out your proposals. She does include everyone on the chain and doesn't cut people out. Mm-hmm. Paula, just a couple of thoughts. If we state we will review the cases in separation, that implies that there are material findings in the Second Sight review and leaves us open to challenge against all cases. It may be better to offer in the spirit of the review and how we have listened to those affected and how we want to change our business. This is the delicate line we are balancing. And from memory, Susan quoted more than 500 cases in the last 10 years. It may be an option to allow sub-postmasters to come forward and request a review. I agree on the points about the working group and user group, etc. Did you bring into account in your decision-making the views that the head of IT was giving you on the extent to which that the Post Office should itself ask independent lawyers to review past convictions?
I would have read Leslie Sewell's email sent to me. I wouldn't take any decision on legal matters personally without the advice of the General Counsel and on something this significant as the board.
We can see that you've had what the PR expert has been telling you to do about past convictions, and here the head of IT telling you. I think your position is that you did not see Simon Clarke's advices which address looking at past convictions until after the Court of Appeal Criminal Division disclosures in late 2020, early 2021.
Yes.
Is that right?
Yes.
So you didn't know that there were lawyers advising on the very issues that you were considering at this time, bringing into account the PR man and the IT lady's views?
I had no sight of the Simon Clarke advices, no.
You tell us in your witness statement, that can come down, thank you, it's paragraph 562, no need to turn it up, that you recall that you were told by Susan Crichton that due to advice from external lawyers, there was a need for a review to ensure that proper disclosure had been given in previous criminal cases.
Yes.
You say that you had a conversation with Leslie Sewell in which she told you that the Post Office had been advised that the expert witness that the Post Office had used in criminal cases to give evidence about Horizon had failed to mention there were bugs in Horizon, including in the Seema Misra case. You tell us that in your witness statement.
Yes. Yes, that's right.
Can we please try to pin down the date on which you had knowledge of a problem with the Post Office's expert evidence?
It's difficult to find the date exactly. I remember that I learned of it first from Leslie Sewell, not from Susan Crichton. What had happened is I passed Leslie in the corridor. She was looking particularly concerned or grumpy about something, and I asked her what was the matter. And she said that she had just heard that, so I don't know that she said this, but I'm assuming from Susan, that the Post Office expert from Fujitsu, whom we had used in past cases, now had to be stood down because he had not revealed, and as I said yesterday, I think 1 or 2 bugs that he knew about in a case. And that's right, I think it was Mrs. Misra's. And the reason that Leslie explained he hadn't revealed those bugs in that case is that they hadn't been, Mrs. Misra's was a Horizon Online case, and these, the other way around, Mrs. Misra's case was on Legacy Horizon, and these bugs hadn't come into effect until Horizon Online.
Ms. Vennells, the way you've described it there is that Sewell was telling you that the expert had failed to mention bugs in one case, and that was Seema Misra.
I think
In your
so.
witness statement, you say that she told you that he had failed to give disclosure in criminal cases, including Seema Misra.
Right, that's probably right then. I don't
Again, can you help us
yes.
as to the time of this, please?
Well, I then spoke to Susan, I think within a day or so of that conversation. Susan explained more about it. So if you can date when Susan found out, it would have been just before that, because Leslie could only have found out from Susan.
By this time, and I'll call it mid-2013, you had been engaged on the issues of Horizon integrity for some time, hadn't you?
From when, yes, yes.
You knew that there had been prosecutions and that those prosecutions had been founded on evidence from Horizon.
Yes.
When told by Leslie Sewell and then Susan Crichton that there was an issue with the Post Office's expert evidence that had been relied on to convict sub-postmasters, including Mrs. Misra, were you concerned?
Yes, and I think Susan had, and I think the documentation says this, Susan had told, at the time I spoke to Susan about it, she said, I think, that she had already put in chain a review by the external lawyers. And I think the documentation shows that she had done that before the written advice from Simon Clarke came in on the 15th.
Did you at the time join the dots between the debates that we've seen you have in emails here with Mr. Davis and Miss Sewell about the extent to which the Post Office should announce that it was going to review past convictions, and the information that you were being given, quite separately, that the Post Office's expert witness had failed to mention bugs of which he had knowledge in criminal cases?
No, I didn't make that link.
Why not?
I think because the emails from Mark Davis and Leslie Sewell are part of an iterative process as to how we took this important ongoing piece of work forwards. The conversation with Susan Crichton about the work that became known as the Cartwright-King SIFT review was, I think I took as a piece of reassurance that the lawyers were doing what they needed to do in terms of and I think this is at the stage where I learnt about disclosure, of what they needed to do in respect of disclosure. What I didn't know at this stage, to be very clear, was that by dint of what had happened with Gareth Jenkins, the Post Office had breached its duties as a prosecutor. I don't think that was mentioned to me at the time.
Did you never at any time connect the long-running criticism of Horizon's integrity that had been forced upon the Post Office by sub-postmasters for years and years with being informed that there was a problem with the expert evidence on which the Post Office had relied about bugs?
I don't think I made that connection because it was very specific. The information I was told was very specific, which was that these two bugs were related to Horizon Online. There were two of them which affected, and by this stage I knew about them, which affected 14 and 62 post offices, I think, all of whom had been informed, or in the case of the 14 were in the process of being informed, and the bugs had been fixed and the postmasters had not lost any money as a result of that. So this was Leslie's frustration, which was that these were two isolated incidents. I accept now that is incorrect. But that was what I was told. They had been fixed. There is even documentation which refers to them as a red herring. And the fact that Susan was going through this SIFT review, to me, seemed to be reassuring rather than concerning.
Did you ask who this witness was?
I don't believe I knew Mr. Jenkins' name because there is...
I'm asking, did you ask who was this witness?
I think I was told that it was a Fujitsu, someone who worked for Fujitsu, who was very competent on the system.
Did you ask how many cases he had given evidence in?
No.
Did you ask what was being done in relation to the evidence that the Post Office was concerned about?
I'm sorry, ask the question again?
Did you ask what the Post Office was doing as a result of its concern that he had failed to mention in cases knowledge of bugs?
I was told that we were going back looking at, or that Cartwright King were going back looking at cases. So
Why were they doing that if it was a red herring?
I understood, because that was the obligation that one had to do, was that any case that he had given evidence in needed to be given this evidence around these two bugs, even if it didn't affect those cases.
Were you told that he was an unsafe witness?
No.
Can we jump forwards, please, to October of this year, October 2013, and look at poll 0038-2001. At the foot of page 1, please. An email from you to Alice Perkins, signing out. Hi Alice, don't worry about the lateness of the note. I'm clearing the tray before I'm signing out. A couple of updates. Sir Anthony Hooper Sparrow, very positive phone call on Friday PM. No issue at all, re Hillsborough. He's going to send a file note. And then my concern, re Sparrow, is currently our obligations of disclosure, re an unsafe witness. The representative from Fujitsu made statements about no bugs, which later could be seen to have been undermined by the second site report. We don't think it is material, but it could be high profile. Is the unsafe witness that you're referring to there the same person that Leslie Sewell and Susan Crichton had referred to earlier?
Yes. Yeah.
Had they described him as an unsafe witness?
I don't know where. I only saw this disclosure recently, so I haven't had a chance to go back and see whether an unsafe witness is not a term that I would have used. So, and the other thing that
you did use it.
Yeah, sorry. The adjective unsafe is not something in relation to the word witness. It's quite a specific description, and I'm not sure that that's something that I would have just used coincidentally. And when I looked at this email, this is some considerable time. So this is 3 months after I found out about Mr. Jenkins being stood down. So I don't know whether at this stage I had been given more information about him or not.
It's 6 days after, it's 6 days after Mr. Altman did his general review, a document which I think you say you weren't told about and didn't see.
No. Does he use the term?
Not precisely, but in any event, you understood that there was an issue by the date of this email concerning disclosure that related to an unsafe witness, correct?
Yes.
And that related to him making statements about there not being bugs in Horizon.
That was my understanding.
So you understood by this time that there was an issue about the reliability of the Fujitsu expert evidence about there being bugs, i.e. the absence of them,
Yes.
and not merely about the presence of bugs that have been revealed by the second site report.
That's what it says here.
Yes.
Yes.
And you say, we do not think it is material, or it material, but could be high profile. If the issue of the expert evidence in criminal cases was not material, why would it be high profile?
I suspect this is the media aspect again, which is the worry that something that could be taken out of context. I'm not entirely sure, because whether I was given this information very quickly, because I'm clearly going somewhere, and Martin Edwards is briefed to give Alice more detail. I just have no recall of this at all.
Who's the we in that sentence?
I can only imagine that this has come from, well, it wouldn't, yes, possibly Susan Crichton, the legal team.
Where is it recorded that what it was alleged that Mr. Jenkins had failed to do or had done was not material?
I don't know. I would not have personally been able to make that statement without getting it from someone who knew. I didn't understand about, as I now do, about the nature of an expert witness.
There existed at this time the Simon Clarke advice of the
Yes.
15th of July 2013, which addressed page upon page this very issue, the materiality.
I'm sorry, I think I've just remembered. I'm sorry, I didn't mean to cut across you.
You go ahead.
I think Cartwright King had said that, because they had obviously by this stage done a number of checks across sub-postmaster cases, and I think they had said that the disclosures were a fairly small number, and that may be what this is relating to.
So material means not many.
It could be that, yes.
As I was saying, there existed at this time the Simon Clarke review of the 15th of July 2013 on this very issue, the materiality of what Gareth Jenkins had said in witness statements and to a court in oral evidence. But you hadn't been given it.
No. No.
Did you even know that external lawyers had been instructed to advise on the very issue that you're debating?
Do you mean in the sense of the Cartwright King review?
No, the materiality of what Mr. Jenkins had said or had failed to say.
I don't think so.
Do you know where you got the idea that we do not think it, i.e. The expert witness making statements about there being no bugs in Horizon from?
I'm sure there is something in the documentation about numbers of cases. I was not personally involved in any of this at all. I mean, I wasn't working with the external lawyers doing the review, so I couldn't have known what they did or didn't think. And therefore, it can only have come through the legal team. Or possibly Martin. I mean, it is possible that Martin was briefed by, but again, he would have had it through the legal team.
isn't the material comment here another reference back to the supposed red herring rather than about numbers?
I don't think so.
Why not?
Well, only in the context that... No, I don't, that isn't what I understood. And there is certainly something in documentation somewhere that makes the statement that the lawyers, Cartwright King, did not think that there would be a large number of cases where the disclosure needed to be made.
Can we go back then to mid-July 2013, but probably after the break? So can we say past, please?
Yep, certainly.
Thank you, Ms Vennells. Can we pick up in mid-July 2013, please, by looking at poll 0010-0702? This is a letter from the CCRC directly to you of the 12th of July 2013. If we just look at it, Horizon Computer System, the CCRC is an independent body. Our purpose is to review possible miscarriages of justice in the criminal courts of England, Wales and Northern Ireland and refer appropriate cases to the appeal court. For obvious reasons, we've read the recent media coverage concerning the Post Office Horizon Computer System with interest. Clearly, it would be very useful for us to have more information directly from the Post Office, especially accurate information as to the number of criminal convictions that might be impacted by the issue and what action is proposed or being taken in that respect. We see that the AG was called upon on Tuesday to set up an inquiry. We're in contact with his office about that. In essence, the Commission's role in this is likely to relate to anyone who is convicted of a criminal offence in England, Wales or Northern Ireland, where evidence from the Horizon Computer System is relevant, where one, they've already tried to appeal against that conviction, or two, they were convicted at a magistrate's court following a guilty plea. I look forward to receiving your reply. This must have been a very unwelcome development.
I remember receiving the letter from the CCRC. I don't remember personally regarding it as unwelcome.
It arrived at a time at which you would have been told, is this right, by Susan Crichton about the need to review past convictions.
I would think so, yes.
And it would have arrived at a time when you'd been told by Susan Crichton and Leslie Sewell about the concern about the Fujitsu expert witnesses' evidence to the courts, including in the Seema Misra case.
Yes.
A letter like this does not land on the doorstep of the CEO every day of the week, does it?
No.
Would you agree that the right and honest thing to do would have been to let the CCRC know about the Post Office's concerns over Gareth Jenkins?
What I did with this letter was to ask Susan to reply as the legal expert in the organisation. I don't believe that I would have given her direction as to how we should reply to it.
The right and honest
and
thing...
for clarity, I wouldn't have either instructed her to leave things out.
The right and honest thing for the Post Office to have done would be to have let the CCRC know, and know promptly, over its concerns about the truthfulness and reliability of the evidence that Gareth Jenkins had given to court, wouldn't it?
Yes, it would.
That didn't happen for years and years, did it?
I understand that to be the case now, yeah.
Given what was on your mind, what you'd said to Alice Perkins a couple of days before this in the email that we saw, did you think we need to say to the CCRC what we know about Gareth Jenkins?
I don't think we're looking at the same timescale. The email that I sent to Alice Perkins was in October. This is July.
I'm talking about the exchange with Leslie Sewell and Mark Davis. My mistake.
I'm sorry, so what was the question?
Yes, in the light of the exchanges
Yes.
that you had with Mark Davis and Leslie Sewell about the extent to which we have to go back and look at past previous convictions, up to 500 of them, for false accounting. Do you think and the conversations that you'd had with Leslie Sewell and Susan Crichton about the person you now know to be Gareth Jenkins, do you think the right thing to have said in response to the CCRC was, we have got concerns about a key witness in a number of our cases?
Yes, assume, yes, I sound slightly hesitant because I wouldn't have known what let me step back. My understanding and expectation is that when the Post Office receives something like this from the CCRC, that it should respond in the fullest way possible, to be transparent about whatever it was that needed to be shared with the CCRC.
Can we turn forwards, please, to poll 00, in fact, it's a couple of days before this, poll 0040 7582. This is an attendance note of the 10th of July. You're not present. It seems to be between Susan Crichton, Hugh Flemington, and Simon Richardson. Can you recall who Simon Richardson was?
Yes, he was one of the partners from Bond Dickinson who had worked on Post Office work for quite some time.
And then if we scroll down, please, to 6. Thank you. I should just read the introduction to this. There was then something of a general discussion around how they were going to manage the additional complaints and resourcing. Essentially where we got to was quite a lengthy brainstorming session. And then 6, the real worry was around the Fujitsu expert who appeared to have known of some of the problems but not referred to them in his report or statement, even though they could be dismissed. There are non-disclosure issues here. They're looking at replacing that expert with somebody else. And then 7, there was generally an overall defensive air, and the board are also feeling bruised. Stopping there, by this time, was it the case that the board was feeling bruised? This is 10th of July.
These are Simon's words. I certainly don't recall. Well, he's reflecting a conversation he's had with 2 colleagues at the Post Office.
Yes.
It's not an adjective I'd have used in respect of the board. The board were feeling very frustrated. I don't.
Frustrated about what?
That the Second Sight interim report had not, according to colleagues, had not taken account of the Post Office's factual evidence against issues that were raised and criticisms made of the Post Office. And secondly, that it had taken too long and was continuing to run up budgets that to levels that had not been expected.
Do you think that's what this might be a reference to? They're feeling bruised.
I can't think what else it would be a reference to. The board were very frustrated by the criticisms in the Second Sight interim report, which at that stage they were told were, at least in some cases, according to the team, unfounded, because Second Sight hadn't had sufficient time in preparing it to take on board the Post Office's evidence.
The note continues seemingly on the basis of what your 2 colleagues, Susan Crichton and Hugh Flemington, said. There are tensions between people, and that includes Alice Perkins, the chair, Paula Vennells, and Susan Crichton. At this time, were there tensions between Alice Perkins, you, and Susan Crichton?
There had been some difficult conversations. I can't remember exactly. Alice, well, we were all frustrated by the report. Alice felt frustrated by it. She could not understand, and again, there's documentation on this as to why we had ended up in why the business, as she put it, had ended up in the position that it had, with a report that hadn't taken account of Post Office's input and conclusions seemingly reached or suggested. To be fair to Second Sight, they'd said it was an interim report. I had been challenged over that, and there was going to be more challenge to come a couple of days after this in a board meeting. And I don't know what, at this stage, I don't know what conversations had taken place between Alice and Susan. Certainly Susan and I had discussed about how we were going to... We'd had conversations about the first draft of a Second Sight report, which I think she went back to talk to them about, and some changes were made, but nothing substantive. And it was a difficult time.
Were there tensions between you and Alice Perkins?
I don't recall that she had been critical. I mean, Alice was a very straightforward chair, and I generally took feedback pretty well. And again, forgive me for repeating the phrase, but there is documentation on that as well. I'm sure she gave me some fairly straightforward feedback about why this had taken so long, why it was over budget, why the report contained things that the Post Office felt were inaccurate.
The minute continues, I said, that Simon Richardson, that I thought the Minister had dealt with the questions extremely well and looked in control of the brief. Evidently, she had the Post Office in to tear them off a strip for not putting someone up earlier in the day for interviews on radio and TV. I said, my view, it was a good thing that no one was there. It was a no-win given the nature of the complaints, and some are sub-postmasters who were generally reporting rather wild stories of what had gone on. However, I understood the political imperative of somebody being put up. Susan Crichton said she would pass my comments on to the comms director. However, I told them that my view was they need to be much more on the offensive about this. This was a new management team who put in place a new independent report and were dealing with the problems. The chair, that's Alice Perkins, seems to have been taken by surprise by the reaction and the noise generated. Paula Vennells may be sensitive around some of these issues happening on her watch as the network director. I said I still thought there were positive messages to deliver and people just need to get into a different mindset. She said that Paula Vennells had asked about what I knew and she might pass on my comments to her. I said I was happy to talk to Paula Vennells since we knew each other from another difficult project in the days when they were a subsidiary of the Royal Mail Group, etc. In your approach to the reaction to the Second Sight report, were you sensitive that some of the issues it addressed happened on your watch as network director?
No, I wasn't.
The note says that the real issue here, the real worry, was around the Fujitsu expert who appeared to have known some of the problems and not refer to them in his report or statement. There are non-disclosure issues here. Was the result of this meeting fed back to you?
I don't believe so.
Would you be surprised that members of your team were having this in-depth and frank conversation about Gareth Jenkins being the real worry that was facing the Post Office after the interim report, and yet this information not being fed back to you, nor indeed to the board?
Yes, I would be surprised at that.
How's it come about that they're having this very frank conversation with somebody with whom you have a history, as is referred to here, Simon Richardson, and you never get to know about it?
Oh, my history with Simon Richardson was one case that we sat on at Royal Mail Group where we were on an appeal panel and working with him a long time ago on post office closures, but I hardly met with Simon.
It's recorded here that she said that Paula Vennells had asked about what that Simon Richardson, knew. Do you know what that's a reference to?
I don't. If you'd like to take me back up the email in case there's something there that prompts
It's an
it.
attendance note, but yes, let's go back up.
It may simply be that I was asking for what Simon's view was on the work that was underway, because he was the partner for the post office, or had been a partner for the post office.
Again, asking the general question, how is it that two relatively senior members of your team, Susan Crichton, the General Counsel no less, were having this frank conversation with a solicitor, and the outcome of it never reached you or the board, if your evidence is correct?
To be honest, I don't know whether Susan, as you've heard previously, it was not a process in the post office which was wrong for advisors, if this is considered advice, which in a sense it is, to be fed back. And the reason I was looking down the list of numbered points is in case any of it was fed back and some wasn't.
Is it every day of the week, though, in the post office that it is told that the safety of its convictions, its criminal convictions, may be called into question by unreliable evidence given by an expert
No, Mr.
witness?
Beer, I agree. It should have been shared.
You were explaining perhaps why it wasn't shared because of a convention of not giving counsel's advice or solicitor's advice documents to the board.
Yes.
That
But it
doesn't
should have
prevent
been.
any of the
No.
substance
Yes, I
being
agree.
conveyed, does
Yes.
it?
No.
So what's at work here in your view? Why is this information not coming back up to you? You've got Cartwright King through Simon King advising on the one hand. You've got Bond Dickinson advising here that the real worry is Gareth Jenkins on the other.
My hesitation on this is that I now know much more than know much more than I did at the time. So I'm now aware that Mr. Jenkins had never been briefed as an expert witness. I don't know whether this is suggesting that that was part of the real worry, or whether the worry that is expressed at point 6 is what the organisation knew already, which was non-disclosure issues, because the Cartwright King review had started by this stage. But I'm afraid I can't help you why more of that wasn't shared.
Thank you. If we move on, the Second Sight interim report was in fact published on the 8th of July. The reference, we needn't show it at the moment, is poll 3029744, and it referred to 3 bugs in Horizon: the receipts and payments mismatch bug, the suspense account bug, and, although it didn't name it, the calendar square or Falkirk bug. If we just look at your witness statement, please, it's paragraph 253F on page 111. Page 111, please. And if we scroll down to F, please. You say, I was not made aware between joining the post office in 2007 and early 2012 that any bugs, errors or defects had been identified in Legacy Horizon or Horizon Online. And then you say the first that I knew that any bugs, errors or defects had been discovered was in mid-2013, when I was made aware for the first time that the bug known as the calendar square problem in Legacy Horizon and 2 bugs in Horizon Online receipts and payments mismatch and local suspense account problem. Can I ask for your assistance on what your evidence means here? You state in the first sentence that you were not aware until early 2012 that any bugs had been identified in either system. And then in the second sentence, you say the first that I knew that any bugs had been discovered was in mid-2013.
I'm sorry.
They appear contradictory.
Yes, they do. I'm sorry. So sorry.
So what's the correct answer to the question?
correct
When did you
answer,
first
yes,
know of any bugs,
2013.
errors or defects?
2013.
So why did you say here that it was early 2012 that you were made aware that bugs, errors and defects had been identified in Horizon?
I don't know, because the only thing I can think as an explanation is that the local suspense bug was, I think, drawn to the Post Office's attention in 2012, but nobody knew about that because it had been referred to the NBSC, and that I suspect this is just a mistake.
So the correct evidence is that represented in the second sentence?
Yes. Yes.
Is that right? And the first is just a mistake?
Yes. Yeah.
Can we turn to what was said in the run-up to the second site report about the Post Office's position on the 3 bugs?
Mm-hmm.
Can we look, please, at poll 0010 5632? Can you see this is an email to you and others from Olwyn Lyons? Read the James brief. And she says, Paula, the only thing that's not in the brief for James is our move away from, quote, there are no bugs in Horizon, to there are known bugs in every computer system this size, but they're found and put right, and no sub-postmaster is disadvantaged by them. It would be good to be able to go on and say, or has been wrongfully suspended or prosecuted. Did this represent a move, a shift in position, preemptively before the second site report, from there are no bugs in Horizon to the then altered position that's set out by Olwyn Lyons?
It was, so firstly, I don't recall, and I think Alwyn said this on Tuesday as well, that there had been a line, as it were, that there were no bugs in Horizon. I don't remember, and I haven't seen it anywhere as being used, but it would be completely right for the Post Office, if that was a line that it had used, to correct it.
I mean, if that's
it
right,
wouldn't have been done preemptively because of the second site report. It would just have been done because it was the right thing to do.
if that's right, that there hadn't been a position adopted by the Post Office of there are no bugs in Horizon, this email makes no sense.
No, I agree, and they're written as lines in inverted commas. I can only assume that this came from Mark Davis and the communications team. I don't recall having a conversation about that.
You tell us in your witness statement that it's paragraph 389 on page 183, no need to turn it up, that after the receipts and payments mismatch bug and the local suspense account bug came to light, as you put it, in May 23, we no longer lived in a world where no bugs had been found in the system.
Yes.
That was your position and the Post Office's position up until at least May 2013, that no bugs had been found in the system, wasn't it?
I think that's right. What I'm trying to say here is that I don't remember seeing it as a line in communications. But as soon as we had discovered these bugs, if we had been saying publicly that there were no bugs, clearly that needed to be corrected.
In any event, in May 2013, you no longer lived in a world where no bugs had been
Yes.
found in the system.
Yes.
In your position as chief executive, was that not very significant information? We've got 3 bugs, or had 3 bugs in the system.
It is significant. At that stage, it doesn't make any difference, but there were only 2 that I knew of. And what was very important to me, and the inquiry can see this from emails that I sent and work that I did, was that, and I can remember saying to our Lions actually that I wanted to demonstrate leadership in this case. This was around the local suspense bug, that it was that I wanted reassurance that Fujitsu had done as it said, which is that all affected post offices had been identified, that we had looked at whatever the shortfalls were, that post offices had not been held accountable for any of those, or that they were held accountable for any losses, that they were all written to, which they were. And so my priority was to make sure that it was dealt with. In terms of the second bug, the receipts and payments mismatch bug, that I was told had been dealt with, and again it's in documentation that the post offices affected by that had been written to as well.
Ms. Vennells, you tell us time and time again in your witness statement that up until May 2013, you had been told time and time again that there were no bugs in Horizon. You'd been
Yes.
reassured it was the basis on which you'd operated. Isn't this world-changing information for you? In
Yes.
fact, there were bugs. The previous assurances that I've been given were false.
Yes, it was information that changed. The way that I was told about those 2 bugs was that they were, and I'm not referring to previous exchanges elsewhere, but they were incidents that had been dealt with. They were bugs that had been resolved, and that they were red herrings to the work, and they didn't affect any of the branches that Second Sight were looking at, and the branches that had been affected had been properly supported by the post office, and the cases have been dealt with.
What's the answer to my direct question that you had been told repeatedly for 6 years since you joined
Yes.
Post Office that there were no bugs in Horizon? That mantra is key to what you say in your witness statement as to what you did as managing director and previously as network director. It was the consistent message from the business. And then you're told, no, in fact, there are bugs in the system. And you're telling us, but they don't matter, they're just red herring bugs. Did you explore why you had been given false information in the past?
I think, to be really clear on this, because it's important, I was told that what I was told was about Horizon, and I'm not splitting hairs on this. I was told that Horizon, that where cases had gone to court, the courts had found in favour of Horizon, that where issues had been raised, I knew, and I say in my statement, that there were always glitches and issues with the system. I knew that from having visited branches, whether it was the egg timer issue or the blue screens or network failures or whatever.
Let's go back to page 111 of your witness statement. F, you say, I was not made aware between joining the post office in 2007 and, you told us this should read mid-2013, that any bugs had been identified in Legacy Horizon or Horizon Online. The first I knew that any bugs had been discovered was mid-2013.
Yes, yes.
So wasn't it world-changing information? That
I'm sorry. I'm not. What I'm not getting across clearly enough is that this was important, but I was reassured at the same time that these bugs had been dealt with.
And is that reassurance anywhere in writing? Or is it one of these corridor conversations?
I think it is in writing. In the second site interim report, both of them are detailed, and it explains, I think, pretty much what I've said in more detail, but that post offices, that this I now know was wrong, that the system had identified the issues, that they had been fixed, the post offices had been informed, and nobody had been held accountable for any losses, and where surpluses were left in the hands of the postmasters.
Given that you'd not been told before mid-2013 about any bugs in the system, and you were operating on the basis that there were none, on being told that in fact the system did have bugs, would you not have wanted a watertight assurance from Fujitsu that there were no more bugs?
I should have asked for that.
Do I take the answer that you've just given to mean, yes, I would have wanted assurance, but I didn't ask?
I had at this roughly about the same time, or maybe a month before, I'd had a conversation with the chief executive of Fujitsu.
Is this the Fort Knox conversation?
Yes, which had been based around the allegations around what Mr. Rudkin had raised.
That's a separate issue.
It is a separate issue, but I'm not a technical expert, and I'm dealing with challenges to the Horizon system, and I'm working within a context where I'm taking numbers of inputs. I took these seriously, and I accepted the explanations that I had been given, and I knew that those explanations had been based on, but again now this sounds very hollow in hindsight, on work that had been done by Fujitsu.
Can we look, please, at poll 3090219? This is the press statement that the Post Office put out on the publication of the interim report. If we scroll out a little bit, please. You'll see in the third paragraph and following, it says, Chief Executive, you said as follows. Yes?
Yes, yeah.
Did you approve this statement?
I would generally. There are occasions when I may not have been able to, but generally I wouldn't usually put my name to something that I hadn't read.
In particular, where direct quotes are attributed to you in quotation marks?
Yes.
We know that the Post Office had been informed of the receipts and payments mismatch bug in September or October 2010. We know that the suspense account bug had been drawn to the Post Office's attention as an operative problem by at least February 2013. And we know that the Calendar Square or Falkirk bug had been drawn to the Post Office's attention in 2006. Do you know why this press statement did not acknowledge that the Post Office had known about each of the 3 bugs referred to in the second site report for many years?
I don't remember having any conversation about that, no.
You will see that it instead concentrates upon the number of people using the system, the number of branches, the number of transactions.
Yes.
Was that the mantra that the Post Office had used for many years to defend allegations against Horizon?
It was a truth, and it was an explanation that was overused, and I fully accept that now.
Thank you. That's a convenient moment before we move to our next topic, sir. Could I say, I think it's 12:05 now, could I say 10:02, please?
10 to 2.
Thank you.
Yes, Mr. Beer.
That's a good afternoon. Good afternoon, Ms. Vennells.
Mr. Beer.
Can we turn, please, to... we're about to turn to the 16th of July board meeting, 16th of July 2013. And before I do so, can I ask you about a couple of issues, essentially turning on this use of the phrase systemic or systemic issues, and your understanding of it, what it meant, Post Office's understanding of it, and what it meant, and how it was deployed by the Post Office. Can we start, please, by looking at INQ 402021? Thank you. And this is a transcript of a covert recording of a conversation including Susan Crichton, Olwyn Lyons, and Ian Henderson about a briefing of you. Yes?
Yes.
You're not on this call. The next
Right.
call we're going to look at, you are. It seems to pick up part-way through the conversation. And Susan Crichton I should say, this is the 22nd of May, 2013. Susan Crichton says that she, I think, had a chat with Paula earlier on. We had a couple of chats this morning, Ron and Ian, and then separately I've had chats with Olwyn. So I just thought we should probably come back together and try and see if we can move this forward. So Paula agrees that the original scope of the investigation did not go as far as looking at whether it was the miscarriage of justice point, Ron and Ian. So that's not what she's looking for. She's just looking for the systematic or systemic weakness in the Horizon system, but not, as I said, didn't go on to that next point around whether or not it's caused a miscarriage of justice or a suspension of a sub-postmaster, because I think that once you've found it, then it's up to us to look for and see what impact it might be if that happens. Now, I appreciate you weren't a party to this conversation, but it's expressing a view about your approach to what should be and what shouldn't be in the Second Sight report. Firstly, was it your view that the focus of the Second Sight report should be on whether there are systemic weaknesses in the Horizon system?
I can't remember, first of all, the conversation that Susan and I had. So I don't know whether I had raised the issue with her or her with me. I don't remember personally ever sort of feeling that I had instigated the use of the word systemic in some way. That was, the work I understood Second Sight to be doing was part of the terms of reference which had originally been established. I imagine the miscarriage of justice point was a conversation with Susan, because I wouldn't have expected forensic accountants to be working on issues of justice and law, but I can't remember the conversation with Susan to and I'm not sure that this necessarily points in a particular direction that reminds me.
Wasn't we saw the Second Sight proposal earlier this morning, wasn't
Yes.
the purpose of their work to seek to establish whether there had been miscarriages of justice?
You're right. I think that was... I don't know if those words were mentioned in the terms of reference, but if you're telling me they were, I'm happy to accept that. But they were to look at individual cases to see whether there was anything as a result of horizon issues that could have caused that. I don't imagine Susan would ever have, and myself even less so, would ever have thought that Second Sight would then go on to look into whether there was a miscarriage of justice, because clearly that's a legal issue, not an issue for a forensic accountant or the detail of the work they were doing.
But when Second Sight reported, you raised the issue, which is essentially referred to here. It's up to us to look at the impact that their conclusions had. And we saw in your exchange with Leslie Saul and Mark Davis this morning, you raising, have we got to go back 12, 18 months? Have we got to look at 500 convictions for false accounting? Have we got to go back a decade? That was never done, was it?
No, what you saw me raising was questions about, whereas I said earlier today, naive questions in a sense, but important questions about what this work could do and why the Post Office wasn't considering going back further. It wasn't that I was saying we shouldn't. I was simply asking the questions to understand better.
The way this is explained to Second Sight here is you, Second Sight, on Paula's instructions, should look at whether there are systemic weaknesses in the Horizon system. It's for us to work out whether there have been miscarriages of justice. We will see what the impact of your report is on our convictions.
And I think that's what I understood, because Susan was the General Counsel, and that would be a decision for a lawyer to take forwards.
And so why wasn't that done? Why was a mediation scheme set up instead?
I don't know. It was Susan who called me to talk about the mediation scheme. We've seen the background of information that I wasn't party to, in terms of the original advice from Richard Morgan or the discussion that took place. As I sit here today, we would have been better doing two different things. We could have had a mediation scheme that worked for non-criminal cases, and we could have, but in a sense, it sort of migrated to this. We could then have done a separate investigation, which Second Sight were involved in, which may have thrown up information for disclosure, which sub-postmasters could have taken through to appeal through the courts. As far as I understood it, Post Office itself couldn't instigate that process. What Post Office could do was to instigate a review that potentially could lead to that.
Here it records that you are not looking for them to look at miscarriages of justice. And in the event, you didn't look for the Post Office to look for miscarriages of justice either, did you? You set up a mediation scheme instead.
We set up I don't think I understood at this stage, and I don't think others, I don't think I understood when we set up the mediation scheme that it was going to finish in the way it did for the criminal cases. The Post Office, the very original legal advice that Susan took from Richard Morgan was then almost repeated 2 years later by Brian Altman, I think it was Brian Altman, to say that you can't resolve criminal cases through a mediation scheme. And the advice was very strong that the Post Office shouldn't put criminal cases through the mediation scheme, and what it should do is to continue to do the detailed investigation, which itself might then provide sub-postmasters with information to take through the Court of Appeal, and some had already gone into CCRC.
You knew that James Arbuthnot's main concern was miscarriages of justice, didn't you? I
did, yes.
Can we turn, please, to SSL 40128? This is a transcript of a covert recording with the Post Office team and you of the 2nd of July 2013. Can we look, please?
This is with Second Sight and the Post Office team, yes?
Yes.
Yes.
Yeah, sorry, Ina Henderson and Ron Warmington are both on the call. And we'll see in due course that on the Post Office side, there is included Leslie Sewell, Simon Baker. I think that's it. If we look at the foot of the page, please. Simon Baker says, just to let you know, Paula has now joined us. And then top of the next page, you say, hi, Ian, and Mr. Henderson reciprocates. Then if we can go to page 3, please. Under Ron Warmington, he says to you and the call, that's Mr. Arbuthnot's main theme continues to be the possibility, whether there exists a possibility of wrongful prosecution, or for that matter, wrongful civil action, but he's less concerned about that. Mr. Henderson, he's certainly referring to miscarriages of justice. We've obviously briefed him on the defect issue. I don't know to what extent he's been previously sort of briefed on that, but he seemed very concerned about that. He didn't know, suggest that it was a cover-up, but he said, I find it quite astonishing that it's only now that that information is coming to light, bearing in mind that these were, events and so on that occurred, up to 3 years ago. Simon Baker, just for the record, before the room can be clear, written to the sub-postmasters about that and how many court cases we had mentioned if we for information only. Leslie Sewell, in terms of responding to that, can we make it clear that that is all in the public domain? At this point, did you understand that to mean the information that Second Sight had uncovered about the existence of bugs, Simon Baker and Leslie Sewell were saying, was already in the public domain?
I think Leslie here is saying something that I remember her being irritated over, which was that she had said, and I think she said in her evidence last week, that she had told Second Sight, and I think it was being said that Gareth Jenkins had told Second Sight. And I think what she's referring to here is that it was Post Office who told Second Sight. There was no cover-up about that, and this was about the 2 bugs. I don't know what happened about Callender Square, Falkirk.
Was she saying there that all of the bugs were in the public domain?
She is saying that there, but whether she was... But my recollection was that her emotion, as it were, was around the fact that it had been said somewhere that it was Gareth Jenkins who had told Second Sight, when Leslie... I understood it was clear that it was Post Office that had told them.
So certainly no cover-up, but it's absolutely in the public domain. Was the existence of the receipts and payments mismatch bug absolutely in the public domain as at July 2013?
I think she's referring here to what was in the Second Sight interim report.
This is before the Second Sight interim report.
What date is this, please?
2nd of July.
Well, it wouldn't have been in the public domain by then, no.
No, but she's saying it is. She's saying it's absolutely in the public domain.
I think... Well, I can't comment exactly on what Leslie's saying here, but I'm trying to help by saying that my recollection was that her response... it was the word cover-up, because I think she was responding to the fact that somebody had said the Post Office hadn't disclosed these bugs, and her view was that the Post Office had disclosed the bugs to Second Sight. And of course, in terms of them being in the public domain, the postmasters had been written to. So
that
you'd have to go back to Leslie to get...
Was it?
Sorry?
That's what you understood putting it in the public domain to be?
that was my understanding of what Leslie was meaning by this comment, that this at this distance from the conversation.
Yeah, that they've been through court cases. Was she saying that these bugs have been disclosed in court cases, to your understanding?
I mean, that would be...
Was it something she said to you? Look, we've disclosed these bugs before. Receipts and payments mismatch bug and local suspense account bug in court cases.
No,
no
I
cover
don't
up
think
here.
so, Mr. Beer. My only recollection on this is what I've just said, which is she wanted to reassure me that it was Post Office that had told Second Sight, not Mr. Jenkins. And I can't comment on the line about other court cases, but there is a possibility that that's the link through, because the reason Gareth Jenkins was stood down is that he hadn't mentioned... I'm not entirely clear, I'm sorry.
Okay. Mr. Henderson, I think the point was, until the last sort of few days, but certainly, so he was certainly unaware of that. And I think there was a feeling, bearing in mind that this investigation was set up 12 months ago, there was a lengthy and protracted build-up to that. Why is it only now he's hearing about this? That may be a valid point. Mr. Warmington, he said something like, they haven't told me about it, they haven't told me about it. Simon Baker, I think we ought to register that point. I think I was discussing it, probably not going to, okay, can we just keep going then? What else transpired at the meeting? There's then some discussion about what transpired at the meeting between Second Sight and Mr. Arbuthnot. Then at the foot of the page, Leslie Sewell, 4 lines from the end. The other point around the system itself in terms of the cases, there's nothing material been found in terms of Horizon. Was that made clear to James? Mr. Henderson, well, no, because like us, he is using this broader definition of Horizon. And I think like us, I know Simon, you said yesterday, we've just got to agree to differ. I think if you look at that wider definition of Horizon, if you look at the totality of the user experience, what you, I think, collectively sort of identified as sort of, process changes, opportunities and so on. He's putting more into the category of using that definition sort of defects in Horizon. Leslie, sorry to jump in, but that's not what we talked about yesterday. We were absolutely clear yesterday in terms of how we carve up each element of the process, so the system, so that we are absolutely clear where we've got the issues we do need to address. Leslie, we were crystal clear on that. However, I don't think you'll find he cares. From his viewpoint, it doesn't matter whether it's software, code, or the procedures. And then there's an example of a spot review involving scratch cards. If we go over the page, please. 4 paragraphs in Ian Henderson. Simon, the message is, don't rely on this narrow definition of Horizon. I think, frankly, any references to software and so on are not going to help your case. James is operating well beyond that. He, like us, is looking at the totality of the user experience when he's talking about Horizon. And over the page, please, to page 7. Uh, 4 paragraphs in. Simon, I don't think we can be categoric like that. Trying to compartmentalise, frankly, is going to backfire on you. That's the message we're picking up from James's office. He's got no time whatsoever for these semantic definitions and distinctions. He wants all of us to stand back and actually, think about the bigger picture and totality of the user experience. Then foot of the page, you say, I understand the message you're giving us. I've something semantics. I think there are very different things here between, a systemic problem with the Horizon system that brings into question all the transactions and the fact that it's not a user-friendly experience for user sub-postmasters. And we need to, and I said this yesterday, the number of transactions we do, the number of branches that run, and the number of complaints we've had, even though we've been out and advertised and have been very open about them. As a result of this conversation that you were a party to, what did you understand Second Sight to be saying as to their approach to the phrase or definition of systemic issues?
They were, and there was a line in here that we've looked at. They could understand the difference that what was, I think, going on here, and then there is further documentation about it, is that as the interim report was published, it was important to the Post Office to make the distinction between the findings of the report about the system, so which were at that stage they had so far found nothing, no systemic issues with the Horizon system, and the wider system issues around training and support.
Stopping there,
And
what do you understand no systemic issues with the Horizon system to mean?
at that time, my understanding, because we were trying to make the clarification so there could be no misunderstanding, was that they had found no systemic issues with the technology.
What does
But
systemic
they had
issue mean?
found. So something that was wide-ranging across the system. I mean, they make the point in there, the scratch card issue, which by this stage had been fixed, had generated, I think, was it 700,000 transaction corrections? It was a systemic issue. It was something that could have affected a single post office and in fact affected a number of them. But what they were also saying was that they had come across other issues around processes and support and training. And what Post Office was trying to do at this stage was to accept both, accept what they were saying in a sense, although on the training and support issues that I think there were some challenges, to make sure that when any reporting on this happened in the media, there wasn't a headline that said bugs being found in or in the Post Office system. So I think that was the nature of this conversation at this stage, and I think Second Sight understood that, as did Mr. Arbuthnot, because we had that conversation later, and there is a minute on that somewhere.
Did you understand systemic issues to mean an issue which affects the entirety of, i.e. all of the system?
Do you mean including the training and support and process issues?
No, just on the technology front.
I think at this stage we had understood it to mean the technology front.
Yes,
Yes.
i.e. a systemic issue relating to the technology,
Yes.
in order to be a systemic issue, had to affect the entirety of the estate on that issue.
Yes, or a scale of branches, yes.
Or a scale of branches.
Yes, so
what was the scale of branches that it had to affect to be a systemic issue?
I'm simply thinking about I think it was the scratch card issue that was given as an example. That affected numbers of branches, but I don't think all of the branches. So it was a system issue in terms of interfaces, and some branches, actually that was probably
What about an issue that affected the balancing of 500 branches? Was that a systemic issue?
I think I had accepted the definition of systemic that Second Sight themselves had said.
Which
I
was?
wouldn't have said, I can't remember. It wasn't the point we were talking about here. It was earlier. They had talked about an issue that would, I think it was, they talked about system-wide or something like that.
So, can I understand your evidence correctly? You at the time understood Second Sight's reference to systemic issues as meaning an issue that affected, on the technology front, all of the estate in relation to that issue, or a very large part of the estate on that issue.
Yes, I think so.
would it cover an issue which affected the balancing of 500 branches?
That would be a serious issue. I don't know that I went into any numbers of branches. I didn't think about numbers of branches. I simply accepted the definition that they, as experts, had given. And I think their wording was, it wasn't every branch, but it was it gave you an indication that it covered a large number, or it may have been system-wide. I can't remember.
You know that the Post Office went on to use this phrase
Yes.
year in, year out afterwards in order to defend its system.
Yes.
Did it not occur to you that there was a category of case involving a large number of branches which may have experienced a problem with Horizon's systems, but which didn't affect every branch?
I don't imagine that I ruled that out at all, because the ambition behind the scheme that was put in place was to look at all of the branches that came forwards and all of the issues that came forwards.
Can we turn, please, to the board meeting of the 16th of July by looking at poll 3099218. This is a report prepared by Susan Crichton for that board meeting, entitled Post Office Board Update following the publication of the interim report on Horizon. It's dated the 12th of July 2013. So I'm going to call it the 12th of July board report. And you tell us in your witness statement, it's paragraph 519, that this was made available to you at the time before the 16th of July board meeting, correct?
Yes.
The purpose of the paper is recorded to be to update the board on the latest events and seek input as to how the business moves forward, with the 3 new initiatives outlined in the press release of the 8th of July and explored further in this paper. If we scroll down, there's some background, and then if we look at current activity underway, and then go over the page, and 3.7 records one of the pieces of activity underway is, on the advice of our external criminal lawyers, we've immediately begun a review of our criminal cases conducted since separation on the 1st of April 2012. More detail on this is set out in Annex 1. That date there, the separation date of the 1st of April 2012, as being the date of the review, I think must be an error. That was the date of separation, but it wasn't the date that the review went back to.
No.
As we'll see when we look at Annex 1 itself. They went back to January 2010.
Yeah.
And if we scroll down, proposed way forward, 1, the working party overview will establish a working party to include the JFSA to complete the review process and look at the thematic issues which have emerged. 2, continued involvement of Second Sight. Following the meeting with James Arbuthnot and MPs, and the comments made in the House, it's clear that Second Sight will have to continue to be involved in this matter. We're currently considering how best to manage this and to use the work already completed by them, mindful of the need of their report to remain independent and a need for a cap on their costs. In addition, following the statement in the House, we'll need an independent chair for this group. Can you help us? Was it the original plan, as per your email to Leslie Sewell and Mark Davis, to part company from Second Sight?
My email didn't say that
No.
as an action. My email didn't refer to Second Sight. And as I said this morning, we were considering whether or not we could bring in additional resource to support Second Sight, whether their involvement should end. There was, I remember, there were, I remember, questions from the board about whether Second Sight should continue. And it became very clear that they should, because they had the ear and the confidence of the MPs and the minister, and that was important. And so they did. And so what the and again, this isn't my paper, this is Susan's paper, but I think from memory what the board then asked us to do was to think about how we could support Second Sight so that the work could be progressed at more pace and closer to the budgets which they had originally agreed, or they were about to sign off.
You make the point this is Susan's paper and not your own. You went on to present this paper. And not
I can explain why, if that's helpful.
We'll get to that, but I mean the short point is she was made to sit outside on a chair.
Yes, yes.
If we go to page 3, please. Under the heading Next Steps, if we go down 4.6, a proactive approach. There are a number of areas where the Post Office wishes to take a proactive approach, for instance, looking at processes for managing our relationship with our sub-postmasters. Further details will be shared. A reactive approach. In respect of the criminal cases, the Post Office should wait for those to be overturned via the Court of Appeal and for claims for compensation to be made. We'll then decide whether to settle or fight. Why was a proactive approach being taken to the management of relations with sub-postmasters, but a sitting back, a reactive approach being taken to miscarriages of justice?
I can't really comment on the criminal legal side of things. I am not a lawyer, and I know you discussed this, or Mr. Blake, I think, discussed this when Mrs. Crichton came in last week, and I can't remember what she said in her evidence, but this was her recommendation, and my recollection at the time was that, as I said earlier today, that criminal cases had to go through the Court of Appeal for any resolution to be reached.
That's a truism, but it doesn't tell you anything about what the organisation responsible for the prosecutions in the first place should itself do to uncover material, to review material, to be an honest broker, to allow the Court of Appeal to fulfil that function, does it?
Yes, I agree, and I said this morning it would have been better had we done a completely separate investigation into this. At the time, I and the board took the advice from the legal team and the lawyers that they were working with that this was the way to do it. It was clearly completely wrong to put criminal cases into a mediation scheme that couldn't have resolved it. But in the mediation scheme documentation, it allows for that. And there
Was
were
that
questions.
a deliberate strategy to do that?
No.
To lump these things into a process that you well knew had no facility to deal with them?
No, not a deliberate strategy on my part at all.
Can we go over to page 4, please? This is the annex that was referred to and is Miss Crichton's note on the details of the criminal cases review. It records, Post Office has been advised by our external criminal lawyers to undertake a review of all cases going back to the time of the migration from Old Horizon to Horizon Online, i.e. 1st of January 2010, and this has already begun. That's the correction to the main paper that I mentioned earlier. They're essentially looking at whether or not anything in the Second Sight interim report should be drawn to the attention of any defendants, current or past, and if so, they'll be writing to the relevant defendants, providing them with a copy of the report. We have a continuing legal duty as prosecutors to do this. Important to note, we believe that we have undertaken about 55 prosecutions a year for the last 10 years. The lawyers advise us that they believe there will be around 5% where they need to disclose additional evidence, and it will be up to the defence lawyers to consider the evidence and apply to the Court of Appeal. Each individual has to seek leave, etc. We may also face civil suits for wrongful conviction. The consequences of this, I think the causes of action are malicious falsehood, defamation, wrongful termination of contracts, and harassment. 1.4, if we abandon our prosecutions, we may also face claims e.g. for malicious prosecution, and over the page. Oh, that's the end. Thank you very much.
Excuse me, if you remember this morning, I mentioned that I had a recollection about the external lawyers thinking there were a small number of cases. I think 1.1 may be a reference to that.
I.e. the 5%?
The 5%, yes.
Now, can we look, please, at the agenda for the meeting? Poll 00371898. We can see at item, this is the agenda for the meeting on the 16th of July 2013. If we scroll down to item 9, we can see that Susan Crichton was after lunch to produce was to speak to the issue of group structure, yes?
Yes.
And then earlier before lunch, Horizon Update item 4, Susan Crichton and Mark Davis were to speak to that issue, yes? And was that the plan so far as you were concerned as you walked into the meeting?
It was the plan, as far as I was concerned, until very shortly, either before the beginning of the meeting or the break. Now I've seen the agenda, it might have been before the break. I was told by Alice Perkins that she, and this was a complete surprise to me, that she was planning to stand Susan Crichton down, and I assume Mark Davis, because she wanted a full and frank discussion in the board meeting. And I think I said two things, I can't recall exactly, that first of all, that seemed unfair because Susan had written the paper and this was a very important matter. And so the second thing was, how were the board going to be properly briefed on this? And her response to me was, well, you can table the paper.
Sorry, stopping there. Presumably you said, as you've said to us a number of times, but I'm not a lawyer. I don't know anything about
exactly
this.
That. I said I can't possibly table that paper. And her reply to that was then, well, you can talk to, I was familiar with some of it, clearly. I could talk to what I could talk to, and the questions that I couldn't answer could be picked up later. And so that happened. And I felt uncomfortable about it.
Can we look at what you said in the board meeting? Poll 3021516. These are the minutes of the meeting on the 16th of July. We see that you are recorded as being present. If we go forward to page 6, please. It's recorded that you provided the Horizon Update, and that's correct. You provided the Horizon Update, is that right?
That's right.
You presented the Susan Crichton 12th of July board report to the board.
Yes, I'm not sure entirely how that happened, but yes.
It records that you explained that although Second Sight's report had been challenging, it had highlighted some positive things as well as improvement opportunities. Is that how you really read the Second Sight report?
Well, that is what is recorded, so I imagine that that was what I said in the meeting, or that was what was taken out of the discussion in the meeting from the paper.
Isn't that to put some, to put it mildly, spin on the Second Sight report? It highlighted positive things as well as improvement opportunities.
I don't believe I was doing that. The board had the paper, and they had they had this board paper, and by this stage, I think the Second Sight report had been circulated to the board, and
so they could read from themselves.
It was an interim.
They could read from themselves whether the thing to take from it was that there were positive things as well as improvement opportunities.
I say, first of all, that it had been challenging. And then I say, and maybe there's a comma missing, it had highlighted some positive things as well as improvement opportunities.
You say
and
that
it had been challenging. There were numbers of challenges in the report, particularly around the training and support issues, and those were the improvement opportunities that needed to be dealt with. I can't remember what the positive
carry
was.
on to say the business had been praised in Parliament for setting up the independent review. The proportionality of the tiny number of cases have been emphasised, and no systemic issues have been found with the Horizon computer system. However, there are cultural issues which had to be addressed to improve the support we gave to sub-postmasters. This was now a catalyst to make changes in the business.
Yes.
And then the board is recorded as being concerned that the second site review opened the business up to claims for wrongful prosecution. What did it say, the board members?
I don't recall this, because when I read this minute more recently, the main recollection I have of the discussion, that I mean, clearly this was discussed, but I don't recall this. My main recollection was around all of the criticisms that had been made that the business had yet been able to respond to. And I don't remember. I mean, this is a minute of a board conversation. This isn't a minute of what I presented. So I've no reason to doubt the minutes at all. But I don't recollect the board asking if Susan was implicated in any way.
I haven't come on to that yet. I'm just asking
I beg
about
your pardon.
whether the board said to you that they were concerned, it was concerned, that the second site review opened the business up to claims for wrongful prosecution.
As I say, I can't recall that.
Do you know how the second site report might open the company up to claims for wrongful prosecution? I thought it had found no systemic issues.
Which is what it said. I don't know whether at the time I understood how the board, whoever in the board, had arrived at that particular conclusion.
Anyway, the board asked if Susan Crichton was in any way implicated in the prosecutions, and you said that up until 18 months ago, Royal Mail Group had run the criminal law team, and many of the cases in the review had arisen before separation. You explained that the business was a prosecuting authority and as such brought its own prosecutions. Since separation, the General Counsel had proposed moving to the more normal position of using the CPS for prosecutions. This was being explored. Is that right? As at 16th of July 2013, using the CPS to prosecute was being explored?
I don't know how much it was explored. The only recollection I have, and it's a fairly constant recollection about discussions on the CPS, was that whilst that would have been, I think for those of us who were lay people in the sense of legal expertise, that would have been an option that should have been considered. The constant feedback we had about the CPS was that they were stretched, that there were budget issues, that there were resource issues. There was a further point and a lot more detail in a report, in an advice that Brian Altman.
Ms. Vennells, I'm just asking at the moment, did you tell the board on the 16th of July 2013 that
if the minute captures
the
this, then
use
yes,
of the CPS
yes,
was being explored?
Yes.
Where did you get that from?
I can only imagine the General Counsel.
Susan?
Yes.
The board expressed strong views that the business had not managed the second site review well and stressed the need for better management and cost control going forward. The board accepted it was an independent review and therefore things could happen that were beyond the control of the business. The things that could be managed by the business needed to be well managed with strong leadership. The board asked you if you had considered changing the person leading for the business. That's a reference to Susan Crichton.
It is, yes.
Did they ask you, had you considered relieving her of her duties?
I don't recall today, but I'm sure they did if that's captured in a minute.
And what did you say?
I think my response was, which is documented further on, is that I thought that Susan was the right person to lead it going forwards, and that what we needed to do was to support and put better project management in place to help her do that.
You are recorded as F as saying you had considered this, recognised the business did not have good governance in place around second site. Why did you say the business did not have good governance in place? I'm going to say concerning second site rather than around.
Yes, I don't know whether those are the words or not, but what the business didn't have in place, which it then put in place when we went into the mediation scheme, was proper project and programme management around making sure, as much as it could, although that continued to be a challenge, that the work was progressed in a reasonably efficient and in a manner that was within budgets that had been approved, because the board issues were particularly timing and budget at this stage.
You're recorded as saying that the independence of the review, amongst other things, had made this complicated. Why had the independence of the review made good governance complicated?
The way an organisation like, well, any large organisation like Post Office would work with independent and external consultants is that you would normally agree a work plan, and you would have work streams and you would have timescales related to those work streams. This was, for me, I think as well as everybody else, this was a very unusual situation where Second Sight came in and they were independent, and that was the case all of the way through. They had an idea how they would approach things. They had been asked to keep the JFSA on board or happy. They had MPs who were speaking to them as well. And so this was a very complicated context in which to manage a piece of work. And the board hadn't, I think, really understood the complexity of that. The directors around the board table, the NEDs, other than the chair, had no experience of the complexities of work involving these sorts of bodies and MPs. And their view was this ought to have been very straightforward, and why hadn't it been so?
You're asked to conduct a post-mortem, a review.
Yes.
Is that right?
Yes. In fact, I think I had suggested that to the chairman before this meeting.
And so you presented Susan Crichton's board paper in her place.
Yes,
She was made to wait outside on a chair,
yes, and I felt bad about that.
sitting there like a naughty schoolgirl.
She must have felt terrible.
You presented her paper, you took over the issues, didn't you?
I imagine what I did was certainly not to present her paper, because I was not Susan, I was not a lawyer. I suspect what happened is that I asked the board if they had questions on this paper, and where I could answer them, I would, and where I couldn't, there was an opportunity, as the chairman had said, that people could speak to Susan. But from memory, there was not a formal presentation of this paper, because what happened is the board had a pretty free-ranging conversation about how the Post Office had not managed this piece of work better.
Susan Crichton has told us in the inquiry that she spoke to you before the meeting to say that in her view there would be many successful claims against the Post Office arising from past wrongful prosecutions. Did she tell you that?
I have no recollection of that whatsoever.
That would be very significant information, wouldn't it?
It would. Could you remind me? I heard Susan's evidence. I don't.
Yes. She said that she spoke to you before this meeting to say that in her view there would be many successful claims against the Post Office arising from past prosecutions.
don't recall that at all. My recollection is what is in her paper, which was that the lawyers had found, thought it would be about 5% of the cases they'd looked at.
If she had told you that, that would be about the last thing you wanted to hear, wouldn't it?
No, not at all. I approach this in... Mr. Beer, I would not cover anything up in this process.
Would that be the last? I'm sorry.
I'm sorry, because this is an important point.
That's why I'm asking you about
yes,
it.
I'm sure it is. If Susan had explained that to me very clearly, why in her paper did it say 5%? And if she had said that to me, I never once withheld information from the board, and I had to go in and brief her paper. I'm very sorry, but my recollection on that is I don't recall it.
Did you take over her paper and present it, or the issues in it, to prevent the board from hearing her opinion?
No. I've told you exactly what happened, which is I was expecting her to come in, and minutes before that should have happened, the chairman told me she had decided to stand Susan down.
Did you tell the board about what you had been told concerning evidence that the Fujitsu expert had given to courts, which had led to prosecutions in which he had not disclosed his knowledge of bugs in Horizon?
That I can't remember, because the way it was presented to me was not in the way that I now understand it to have been so important. And I didn't see the Simon Clarke advice of the 15th of July. It was presented to me, as I've explained, as a frustration and something that seemed, that was a logic that I couldn't follow, that Leslie Sewell had explained, and I couldn't follow either. I can't imagine that I would have withheld that level of information, but what you're asking me about is much more serious, and I didn't brief the board on that aspect of it because I didn't know.
Let's try and break that down. You hadn't got a copy of the Clarke advice.
No.
You had been told by two people, Leslie Sewell and Susan Crichton,
Yes.
that there was a concern that the Fujitsu expert had given evidence to two courts in which he had failed to reveal his knowledge of bugs, errors and defects in Horizon.
Yes.
There's no record of you telling the board about that.
No, there isn't. And I don't know at what stage the board became aware of it.
Susan Crichton...
But if I may, the brief that was going to the board was in Susan's paper.
Susan Crichton did know about the Clarke advice, didn't she?
Yes, obviously she knew about the Clarke advice.
Ought this to have been the occasion on which the board was briefed about the Clarke advice?
Yes, it should have been in her paper because she was going to get the written evidence 3 days later. Well, the day she received the written evidence the day before the board.
The Post Office was in possession of expert legal advice to say the expert we've relied on in criminal proceedings to secure the conviction of sub-postmasters is an unreliable witness and breached his duties to the court. The person in possession of that information is sitting outside on a chair. You're not telling the board about it. You have a summary of it on your account. How has this state of affairs come about?
I have been put in a position in the board meeting with no notice to present the paper by Susan. As I say, I don't think there was a formal presentation of it because what took place was a wide-ranging conversation that the board is dissatisfied. And this wasn't in Susan's paper, so I had no prompt. First of all, I had no understanding about the degree of the seriousness of it. and we had by that stage stopped most of the prosecutions. So in terms of it being an immediate need of no longer having an expert, that wasn't a, which might have been my reflection, that wasn't front of mind.
So this is a series of unfortunate events.
No, I was asked to take this paper in that Susan had prepared. That was not in the paper. And I don't suppose it would have crossed my mind to have raised that, because I was not aware at the time just how serious an issue it was.
What would you say to the suggestion that this is the executive team shielding the board from the executive team's dirty laundry?
I'd say it was completely wrong.
That we can manage the problem away. If the board know, they will ask the proper questions. They may ensure that we disclose all of this stuff to sub-postmasters, to the CCRC, to the public, and to Parliament.
I feel very strongly about that, because one of the elements that was so important to me was to have the board challenge, because I was very aware that I was not a legal expert, or an IT expert for that matter, but in this case a legal expert. I relied on my board, and I think there is evidence in the board effectiveness review that I took feedback and challenge and valued it.
The minutes note a list of items for noting, which include a significant litigation report, which itself refers to a separate standalone report for the board. Can we look at the separate standalone report to the board? Poll 309-9218. And can we look at page 4, please? Sorry, it's the same thing, yes. If we just scroll down. There, sorry, it's 1.1. 55 prosecutions a year for the last 10 years, so about 550 prosecutions, in which there may be a need to disclose, in 5% of cases, the additional evidence. What did you understand the additional evidence to be?
I think this was relating to the interim report. I now know that it also included the Helen Rose report, but I don't believe I knew that at the time.
So the board knew from at least mid-July 2013, there was a material risk that around 5% of prosecutions undertaken in the name of the Post Office needed to have disclosure that might lead to appeals to the criminal courts being made. Is that right?
Yes.
Sorry, what was that date again, Mr.?
Mid-July, so
Mid-July, yeah.
The 16th of July to be precise. Were you concerned about that number of cases, or did you regard it as small or trifling?
No, not at all. This was an extremely serious matter, and was something that I was relying very heavily on the legal team to lead and advise on. I do remember the last line of paragraph 1.2 as well, that there had been this, so that this was a serious concern, but there was a small reassurance that it was no means certain that each appeal would be successful.
And what point are you making there?
In that I think I think this is covered somewhere else in another document that Cartwright King had said that. So let me make it very clear, first of all, any wrongful prosecution, any at all, one, would have been unacceptable, and the Post Office needed to do whatever it needed to do in that instance. There was a concern about the number of prosecutions that the Post Office had conducted, and that its external lawyers were saying that it was unlikely to be 550, it was likely to be potentially 5% of that number, and that from their view, having reviewed this, there was a view that perhaps even fewer than that would have been unsafe convictions. And the board, I think, was, and this is, again, this is Susan's paper, this isn't information I presented, but the board would want to have an idea of the scale of what we were going to be dealing with.
And how did it react, the board, to that information in your presence? We may have only wrongfully prosecuted a small number of people.
I don't recall, because I don't know how much of Susan's paper we actually got through. As I said,
again,
I really don't think that I presented it page by page, point by point.
Did you say, I'm not a legal expert, the person that is sitting outside on a chair?
I'm sure I did. But the chairman, I think, positioned it very clearly at the beginning that there was a reason. I think she possibly had the thought of bringing Susan in at some stage. Not sure how Susan would have felt about that. But the board ran out of time and Susan didn't come in.
Can we move on to later on the, or in fact on the same day, the 16th of July, and look at poll 00192088. We'll see at the top there's a reply from you on the morning of the board meeting at 7:05 in response to a Mark Davis email the previous day. Let's look at the Mark Davis email first. 15th of July at 5:51. Paula, I've been reflecting on our conversation on Friday around Horizon. The danger in reputational terms is that the issue rumbles on without conclusion, both before and after the final second sight report. This could really damage the business and hamper NT. That's network transformation.
That's right.
How would the issue rumbling on damage or hamper network transformation?
I believe this was Mark referring to if there was, I'm not entirely sure, if there was either no resolution to the cases that were coming into the scheme, or I had a feeling this was around people being worried about the impact of Horizon, and the issue with network transformation is that we were closing and relocating about 3,000 to 4,000 post offices and recruiting new sub-postmasters, many with existing retail outlets that the post offices were going to be put into. And I think there was a concern that it might impact people's willingness to consider that.
It wasn't to do with government funding, that if this second site issue dragged on, it may impact on the extent to which the post office was funded for network
No, I
transformation.
have seen that, and I think the chairman made a point in relation to that, but that was never my understanding.
Okay,
No.
I'm going to let others ask questions about the relationship between the post office's conduct and government funding. He continues, we need somehow to take the sting out of it in advance of the report. We're taking the right steps in looking to the future. What did you understand him, Mr. Davis, to mean? We need to take the sting out of. the final second site report in advance of it being published.
I'm not entirely sure, actually.
We're taking the right steps in looking to the future. None of these will go far enough to address the damage which some believe they have suffered. These cases will continue and the noise will be louder as the second site process concludes. There's an opportunity here to make a big statement about the kind of business we are and intend to be in the future. We can't, though, issue a blank apology because we just don't know the details of each case. At present, we also face the risk of an open-ended situation where the pipeline of cases is potentially very long. So I wonder whether something like the following would work. 1, we create an independent panel to oversee cases where a sub-postmaster feels lack of training or support contributed to an issue, therefore in addition to the legal review. 2, we proactively invite people to submit their cases to the panel, including writing to the likes of those in the Telegraph piece. 3, the panel's chaired by a QC or perhaps a former MP or peer, scrolling down. 4, it hears evidence from the sub-postmaster and post office on the training and support elements and reaches a judgment. 5, evidence is made in public. 6, we allocate funding to compensate in cases where training and support is judged to have fallen short, but the fund is limited. This is potentially expensive and needs more thought. And then the top of the page, you say this is very helpful. Susan and I discussed last evening with one of our experienced lawyers and came up with a similar idea of a discussion and resolution forum that could be chaired by a professional mediator. We should play into the board discussion and regroup afterwards. Who were the experienced lawyers that you spoke to the previous evening?
I don't recall, I'm sorry. I imagine Bond Dickinson because I had no contact with Cartwright King. I don't think I met ever any of the lawyers from Cartwright King.
Was this the where the idea for a mediation scheme was born, in this exchange of emails?
No,
here?
I think that my conversation with Susan on the station when at the end of my journey home was only me and her. That's my very clear recollection of the first time that we had a conversation about a mediation scheme. And whether she had spoken to Mark as well, because I didn't remember Mark making this recommendation until I saw this document in the inquiry disclosures. So whether Susan and I had had a discussion and I asked her to set up a call with somebody so that I could understand it better, I'm not sure.
Let's move forward to the 26th of July when you go back to the board. Poll 406590. This is a document dated the 26th of July. It's further in paragraph 1, as it says, to the board discussion on the 16th of July and provides an update on how we're taking forward the programme of work in response to the publication of the second site
I'm sorry,
report.
could you just give me the date again?
26th.
Thank you.
I think. I'll just check that. Yes, if we go to page 8.
That's fine, I'm happy to take your...
At the foot of the page. 26th
Thank
of
you.
July. So it appears that this document was prepared, is this right, for the board in response to the actions that the board had asked you to take on the previous occasion?
Yes, I think so.
Not the post-mortem.
No, this isn't the post-mortem. No, this is I think, next steps in terms of work going forwards.
And then if we scroll down to paragraph 4, I should have said to start with, did you write this?
No, I didn't write it.
Who wrote it? Who wrote
I
it?
think, I heard Susan question who wrote it. I think Martin Edwards wrote this. And
Your chief of staff?
my chief of staff, but there is. I mentioned that I have offered to, somewhere. I mentioned that I have offered to Susan to be able to use Martin to help her as an additional resource. Martin could only have written this with input from others.
In paragraph 4, the report to the board says we've been focusing on developing an approach to respond to these expectations, which balances the requirements to be cost-effective, time-efficient and credible, with 2 specific concerns around Second Sight's role. As a 2-man team, they do not have the capacity to deal with all these cases within an acceptable timescale. Their approach of seeking to reconcile the conflicting evidence and views of post office and sub-postmasters, which stems from a steer from James R. Buthnott that they needed to, quote, keep the JFSA on side, is pushing them into an almost impossible situation, which both extends the time taken to conclude each case and, more worryingly, creates a tendency for them to place a greater weight on the sub-postmaster's version of events, irrespective of the evidence we produce. And then page 2. Sorry, I should have looked at the bottom of page 1. We propose to address these concerns, 1, restricting Second Sight's remit to the specific task of preparing an impartial evidential base with no requirement to iron out any inconsistencies. Between the 2 sides' positions, we propose this process of resolution will instead be pursued by employing an independent professional mediator who will seek to facilitate a dialogue between the post office and sub-postmaster to arrive at a sensible conclusion, and 2, changing the way we work with Second Sight by allocating an additional senior level resource with a deep understanding of the network to closely work alongside the team in order to answer their queries and help them prepare an accurate evidence base as quickly and as efficiently as possible. Who did that person turn out to be?
I think that was Angela van den Bogart.
She was the chosen one for that.
She was the senior individual who had the expertise and the experience across the business to do the work we believe needed to be done, supported by a team who also had experience.
Paragraph 6, the mediator is likely to be a senior independent lawyer with specific experience and expertise in mediation. Their role will be to help the sub-postmaster and post office find common ground and hopefully some form of resolution to the sub-postmaster's complaint. Wouldn't have authority to impose a financial settlement or any other form of resolution on the parties. And then page 3, paragraph 11, we also consider the option of supporting Second Sight with additional capacity from another firm. However, this would not address the underlying issues. We therefore concluded that the mediation process, alongside more collaborative joint working and no arbitrary time limit, would be the best way to balance our various objectives. This was the proposed way forwards, wasn't it?
Yes.
A way forwards that meant it was impossible to deal with anyone who'd been convicted of a criminal offence.
I hadn't read that into this.
You thought that this was going to be able to resolve those complaints of those people who had been convicted by criminal offences,
We didn't have any conversation about excluding criminal cases from this, and the documentation that was produced to support the complaint review mediation scheme clearly envisaged criminal cases going into it because there were questions and answers related to if I have a previous conviction, may I submit my case?
And what was going to happen to those that were convicted of criminal offences? How was the mediator going to deal with their conviction?
Mr. Beer, I don't know. I wasn't involved in that. If that conversation took place at all, I wasn't involved in it.
And what's happened to we need to review convictions going back 12 to 18 months. We need to review convictions going back up to a decade. Has that been lost now, that idea?
I'm not entirely sure, but we did have some advice, not seen, from Brian Altman, I think, who reviewed the process that Cartwright King were going through. I believe found that it was fundamentally sound, and there was he looked at the start point, which he decided, I think, was proportionate at the time, but that the post office would need to be open to that going back further if that was necessary.
And were you told all of that at the time, or are you repeating what you've now read?
That's a good question. I'm very clear on that now. I think at the time that is documented somewhere. I'm fairly sure that, not in any great detail, but that I knew at least some of that at the time.
Thank you. So that might be an appropriate moment. I wonder whether we can break until 20 past, please.
Yep. Mr. Beer.
Ms Vennells, can we move on to late August 2013, please, by looking at poll 0011 6218. And page 2. And scroll down, please. There's an email from you of the 27th of August to Alwyn Lyons and Susan Crichton about the draft note for the board. And in the third paragraph, you address a different issue. You say, Susan, a couple of questions. I've just read the mediation pack tonight. Just stopping there, was that a collection of documents that was to be given to putative applicants to the scheme?
Yes, I think so.
Page 10 clearly states that compensation can be a possible outcome. When we discussed this, the hope of mediation was to avoid or minimise compensation. But as far as I can see, the pact doesn't really suggest any other outcome. Difficult to do, I know. And so this will be the page that sub-postmasters will pay attention to. You explain there were steps in place to advise sub-postmasters entering the process. This was a chance to be heard and not to expect compensation. How are we planning to manage those expectations? Where compensation may be offered, you mentioned small figures in the £3,000 to £5,000 band. Can we give a range of costs? Was it your view that mediation was to avoid paying compensation?
No, my view was, as I explained earlier from the conversation with Susan, that it would be, in those cases where it was possible, a way for resolution to have a conversation between, a mediated conversation between the post office and a sub-postmaster. And I'm playing back to her exactly the content of the conversation and the way that she explained it to me. So what I had then seen in documentation was something that was different to what I had expected.
You say here, when the pair of you discussed it, the hope of the mediation was to avoid, i.e. it wouldn't happen at all, or to minimise the amount of compensation. Was that your hope? That the process of mediation would avoid paying any money to sub-postmasters?
No, the purpose of mediation was to seek a resolution. And
why does this say that there then?
Because within that, as I say, it had been Susan's suggestion that, and it had been a conversation about whether this might or might not have been a good idea. And as she explained it, this was one of, I can't remember exactly, but clearly we must at this stage have had concerns about potentially paying out major compensation if it wasn't due. There wouldn't have been concerns about that if it was due, clearly. But the suggestion of mediation had been a way of dealing with what I expected to be cases that where the post office thought resolution could be sought in that way. And we had discussed compensation, and I mentioned there the sort of the small levels of figures. And in fact, we did pay more than that in some cases.
What you're saying here is we've got a private hope of paying out nothing. The document we're giving to sub-postmasters doesn't tell them that.
Well, clearly I'm saying that because it didn't, but I don't think it was a private hope. I don't use that word, and I'm playing back to her the conversation we had, which had been her suggestion, which I thought sounded a very sensible solution.
Was it always your intention that token payments should be made?
That appropriate payments that...
No, I'm asking, was it your intention that token payments should be made?
No, and that word has been used elsewhere, I've seen it. And
attributed to you?
And gratuitous, yes, It wasn't meant in the negative sense that could be assumed. My understanding of the mediation scheme is that it was going to be a conversation around resolution of issues, around understanding and hopefully reaching resolution of issues. And Susan had said to me, and I recall this today very clearly still, that sometimes only an apology is necessary. So I had gone into this assuming that, and with no prior knowledge or professional knowledge of mediation either, as to what it could lead to. And presumably the fact that I still have this expectation here, when I had that further conversation with Susan and a lawyer, I wasn't disabused of that view in that conversation either.
Did you have a discussion, therefore, with Susan Crichton in which you expressed a hope that mediation was a means to avoid or minimise compensation?
I don't remember having the conversation after this. I don't know what happened after this email.
Before this.
The conversation with Susan Crichton was that mediation could be a very helpful way of resolving the misunderstandings and issues that the post office and sub-postmasters were facing, and that it would be an independent way of doing that there was a process of mediation and adjudication. It wasn't done to avoid or minimise compensation.
Why did you write an email?
That was because that was a factor.
Why did you write an email which says, when we discussed this, the hope of mediation was to avoid or minimise compensation? Because
that was what we discussed.
Right, good.
But sorry,
that was easy
but not
then,
as, but not as the purpose of doing it. That one of the aspects.
A hope.
Possibly, yes.
A desire. A good outcome. We don't have to pay any money out.
I'm sorry, you're presenting it in a way that I didn't understand.
What does the hope of mediation to avoid compensation mean then?
Because my understanding was that the conversation around mediation was that mediation would be a conversation, and if it was appropriate, then compensation could be paid, but we were not thinking about large-scale compensation. That wasn't the nature of what I understood the issues to be. That's what I'm trying to say here, and maybe I haven't chosen the words well enough to represent it, but it wasn't. What I'm challenging is that I didn't want us to, I guess, set expectations that the post office couldn't meet.
The sub-postmasters who were raising the concerns were those that had lost money, hadn't they?
Yes.
The post office had forced them to make good the losses, hadn't they?
Yes.
And some of them have been pursued through the courts. Yes?
Mr. Beer, with hindsight, this is completely wrong.
No, at the time you knew these facts, didn't you?
Yes.
Their salaries had been docked or garnished, hadn't they?
They had agreed to money being paid back on a monthly basis.
Agreed?
Yes.
They
were obliged to, yes.
Thank you. You never intended to pay out any substantial figures in compensation for those issues at all, did you?
No, that's right, not in terms of the mediation scheme, because that was not what I had understood it would do.
Can we look, please, at poll 00100336? This is a note in 2014 of the 24th of February 2014. And if we look at page 2, we can see it's Chris Oyard, your interim general counsel's note, back to page 1, of a meeting between you and him on the one hand and Messrs Warmington and Henderson on the other.
Yeah.
In paragraph 2, it's recorded as follows. It was noted by you that the projected level of claims was currently around, I think that's £100 million.
Yes.
In response to which, Second Sight noted their back-of-the-envelope calculation was the order of £25 to £50 million. Your record is as observing this was a long way from the figures that were in mind when the scheme was established, which were much smaller and more of the nature of a token with an apology.
Yes.
When the scheme was established, it was your intention to make mere token payments, wasn't it?
That was the point in the previous email, is that we were looking at smaller... We could not possibly have paid out token payments for the cases that we now know about. At the time the scheme was put in place, and the advice I was given is that this is the way that it would work. And as we got into more and more of the detail and the claims came through, we were suddenly faced with a potential bill of 100 million.
Sorry, Mr. Beer, is this 24th of February 14 or 15? I missed it.
I think it's 14.
14, thank you.
You wanted to minimise the costs to the business, didn't you?
I had a responsibility to the board around the budgets that had been agreed, and this information was shared with the board.
You wanted to give them at most a meagre sum and an apology without really understanding or investigating what the cause of their problems was, didn't you?
No, that isn't the case. All types of cases were welcomed into the scheme, but my understanding at the beginning of it was very different to what it turned out to be.
Everyone was welcomed in so long as they had a pat on the head and a token payment when they left.
I agree that it sounds like that now. That was not the case at all.
You wanted everyone to get the bare minimum, to forget all of this and move on, didn't you?
No.
That can come down, thank you. Did you blame Susan Crichton for the Second Sight review?
I'm sorry, did I blame Susan Crichton for...
Yes, the Second Sight review, the first one, the one that led to the interim report of the 8th of July 2013.
I had a difficult conversation with Susan about...
I'm not asking you whether you had difficult conversations at the moment.
Did
I'm
I blame
did you
her?
blame
Susan had two responsibilities on that. She had the legal oversight as a general counsel, and she was, as she herself has said somewhere, responsible for the delivery or the oversight of the project. And if the project hadn't worked out as had been originally planned, she had some accountability for that part of it. I didn't blame Susan, that wasn't my style, and you will see in documents that I tried to help her through this. I challenged back to the board when they asked whether or not Susan should lead it going forwards, and my view was that yes, she should. I then put in place some additional help, and I met with her.
The board appeared to have blamed Susan for the Second Sight review. Was that in getting Second Sight in the first place through her previous relationship with them, i.e. choosing the wrong people, or a failure to manage them once they had started their work, or both?
I think it was, and I want to be careful not to use the word manage in the wrong way, but I think it was the latter rather than the former. I don't ever recollect anybody saying that it was Susan had brought Second Sight in and that was the root of what the board saw the problem to be.
Okay, so they weren't blaming her for choosing the wrong team?
I don't think so, no.
Can we look, please, at poll 0038 1629? This is, I think, a file note of a number of meetings with Susan Crichton,
Yes.
and then some reflections by you on those meetings. I think
Yes,
the
this
first is wrongly dated the 30th of September. That should be the 30th of August 2013. Is that right?
That's right.
We're familiar with this, so I'm going to take it at some speed. This is in Costa
Yes.
on the Goswell Road. First paragraph, she'd asked me earlier in the week how I felt about her continuing in the business, what job I was expecting her to do. I was slightly surprised she raised the issue again. We'd already had a conversation where I said I wanted to help her restore her reputation after the board discussion. But was her reputation such that it needed to be restored?
That was what she felt. Yes. Well, I suppose that would have been a fair reflection on her part, because the board had asked me whether she was the right person to lead it going forwards. I think that I had reassured the board that I thought that she was.
Second paragraph, Susan was very, very angry. She yelled at me. She thinks this has damaged her reputation. She was upset that Alice had commissioned the RH. That's the Richard Hatfield review. Yes. That's essentially the post-mortem.
Yeah.
She was cross that I hadn't got at the terms of reference before I circulated it to Alice. Alice there and Richard Hatfield, she was convinced there was a breakdown of trust, especially between her and Alice and with the board generally. She did say that all the board except Susanna had been in touch. You explained you hadn't had the time to give her the terms of reference. Next paragraph.
And that if she wanted to make changes to it, I was very open to that.
Thank you. It's clear, next paragraph, that the Hatfield review has destabilised her. She shouted that she was looking at other jobs. She threatened that we'd have to have her back, implying the importance of references. She raised that Alice had made mistakes. You said we probably all had. And Alice had accepted that Hatfield needed to be even-handed. I reminded Susan again that I'd raised with Alice the issue of Alice also needing to be interviewed. I said, whilst I'll be asking Alice about a couple of challenges Susan raised, and then Alice believing Donald, that's Donald Bryden.
Yes.
And Biz comments about a post office cover-up. So you say there to Susan that you would be asking Alice about a couple of challenges that Susan, had raised, namely Alice believing Donald and Biz comments about a cover-up by the post office. So had Susan said to you that Alice believed that Donald and the department believed there was a post office cover-up?
I'm sorry, I don't remember, but if that's what I've said, I think that's what that implies. I don't remember, and there's a question mark at the end of it, so it appears that I hadn't heard that before.
You say you wanted to be loyal to the chairman as you believed that she'd imagined the Hatfield review would be a way of moving on. You note in the next paragraph in brackets, Susan's clearly making lawyer's notes on everything, as were you, I think.
Afterwards, yes.
Yes. I'd like the two of them to repair the relationship. Not sure how doable the latter is, but have to break it down totally at present. To have it break down totally at present is not in anyone's interest. I mostly listened and took the anger. Eventually she calmed down. Said I would genuinely like to help her and find a way back through. She began to be positive as you walked back to the head office at Old Street. Susan suggested I join her and her HR team for a moving on supper. You said you'd be happy to do that and how sorry you were that it had happened so quickly. She'd helped make the function stronger and you were grateful to her. Then over the page, on the 2nd of August in meeting room, you reflected that Susan's request to bring in BD, is that Bond Dickinson?
It is, yes.
was more about her lack of confidence and decided to reassure her I was happy to take her opinions. What was that about, bringing in Bond Dickinson to do, or about what?
I don't recall. I think previously she'd mentioned about... I'm not sure. But I think you just have to take this at face value, that actually I had already said I thought Susan could lead through this. I had given her, we'd had a previous conversation, I'd given her some additional support and a list of things that she could do to sort of address the leadership issues around this. And I wanted to show that I was confident in her.
Next paragraph, Susan told me it didn't matter because she couldn't do her job anymore. The Hatfield review was not the right action for the business. We'd ruined her reputation and compromised her. Professionally, she needed to point out that the Hatfield review shouldn't happen as not being legally privileged. It could be detrimental to the business, but Alice wouldn't believe her and instead see her view as defensive. She could no longer be effective. A general counsel cannot operate if they don't have the confidence of the chairman or board or CEO. I repeated she had my confidence. I cited other business issues in the last several days where I had sought her counsel. I'm trying to repair the situation. She pointed to the impossibility of her ever coming before the board. You disagreed. She will have spoken to all of the board. I reminded her that Alice wanted an open and even-handed Hatfield lessons learned review. If she's right and the Hatfield review is not in the best interest of the business, you needed to understand why. She's sending through the legal case. Assuming she's correct, then she'd need to brief me on how to present the case to Alice. We'd need to explain at the same time how we were going to demonstrate what lessons have been learned.
Excuse me, that may have been the point about Bond Dickinson.
I see. Hatfield is due to see Susan and Angela on Wednesday morning. If I'm going to stop or pause the review, I need to stand him down from those two meetings. Seeing her in her current frame of mind will not help the business or her. As Hatfield is a past colleague of Alice, there are a couple of lessons to be learned here too. Then it would be sensible to tell Alice first. You wondered if Susan was overreacting to the Hatfield review. She could be right. She'll undoubtedly make the legal case against it. Emotionally, she may just throw in the towel if we decide to press ahead. This may also be her way of saying she can't cope with much more pressure at present. If she leaves in the short term, that'll be a major setback. She's stabilised the project. She's demonstrating she wants to right the wrong. My words, not hers. Importantly, the external stakeholders have responded positively. She has the confidence of the internal team. I need to find a way of calming this down and buying time to think carefully. We can do a lessons learned internally. And if we do it ourselves, then there could also be some reconciliation. How we handle this will say a great deal about the values of the business. And then reflections. Susan was very emotional.
Excuse me, may I just make a comment? The line you haven't read is possibly important. Neil was Neil McCausland, who was the senior independent director. And I was obviously going to talk to him about Susan. And that could have been for one of three reasons. I may have asked, because if there's an issue with the chair, you speak to the SID. He may have suggested it because he would have been aware. Or Alice herself, who was generally quite straightforward, may also have suggested that I speak to Neil. So I think...
And we've got some emails that you sending these bits of the notes on to Neil.
Right, okay.
Reflections. In both meetings, Susan was very emotional. She's hurt, her ego and self-esteem has been undermined. She swings between wanting to get away from it all with a settlement and leave immediately, to building a case to fight and defend her reputation, to accepting that the most satisfactory outcome will be to restore her reputation, managing the mediation scheme through to a satisfactory ongoing process. Each time we finish the meeting positively. Susan said to me prior to my leave she would never have put a business she worked for in the situation we found ourselves with the second site interim report. She wished he'd never allowed Alice to persuade her to do the independent review. She should, in her view, have resigned over it at the time. What does that refer to?
That, I think, is what I mentioned much earlier today, which I couldn't remember, or potentially didn't even understand at the time. She had commissioned she had had the meeting with Richard Morgan and I think other lawyers, and had come away from that meeting with a view that there shouldn't have been the review, possibly. I don't know the detail at all around the cases, and I can only imagine that she spoke to Alice about that and I was out of that loop. I think that is what that is.
That doesn't really make sense. She wished she had never allowed Alice to persuade her to do the independent review.
Yes, so...
No female, no woman is doing an independent review, are they?
No, I think my understanding of this, with hindsight, is that Susan had gone to Alice, because you remember that Alice talked about kickback from the business or pushback from the business. I hadn't been involved in that conversation. She had taken advice from Richard Morgan, who had said very clearly this is just a no-win situation. She'd had a conversation with Alice, and Alice had persuaded Susan that we needed to continue with the second site review.
I see. And then you say this, my reflection on what happened with Second Sight, as I write this today, 2nd of September 13, is that Susan was possibly more loyal to her professional conduct requirements and put her integrity as a lawyer above the interests of the business. When had Susan Crichton put her professional conduct requirements and integrity above the interests of the business?
I wrote this completely wrongly. What I was trying to say, if I may, is that, as I said earlier, Susan had two responsibilities here. She absolutely, and I respected it 100%, had the professional conduct requirements of a lawyer as the general counsel. That was her role as the lead lawyer for the organisation. She also had, in parallel, a major project that she was leading and had accountability for delivering for the business, which was this independent review led by Second Sight. And the latter had bumped into all of the issues and problems that we've covered today. And what I was trying to say here very badly is that she had not managed to combine those two responsibilities. And she hadn't, and I think this was her point about she wished she wouldn't have let a business get into the situation it was. She hadn't led the project management side of that as well as she could have done. We had that conversation, and I put in additional resource to support her. And so I'm genuinely very, very sorry that I did not mean this in the way that it could be read. It was about that balance.
It's not the way it could be read, it's the way
that it does read. It's the way that it does read, but I'm really very clear, and the conversation, I don't think there's anything else in the notes of conversations I had with Susan that puts it this badly. But that was the point, is that she hadn't balanced those two aspects of her role. But I was sure, and I think this is now the third time, that I had gone back to Susan to help her, in her words, restore her reputation and give her the resource to be able to lead this going forwards.
Why did you type something that didn't express what you believed?
It's clumsy. It's clumsy, Mr. Beer. But I absolutely did not mean what this reads when you read it in the cold light. And I think there are plenty of other documents around this that show that it was that balance, and it was the project management part of her role, because she was a director of the business leading this piece of work, as well as the lead lawyer.
Did you think there was a choice to be made?
No.
Between, on the one hand, a lawyer's professional obligations and their integrity,
No.
and on the other, the needs of the business, and Susan Crichton had made the wrong choice?
No, I didn't.
Why did you type it then?
I'm sorry. I've tried to explain, because she had these two areas of responsibility, and I think that she neglected the business side, and focused, as she had to do all of the time in her job, on the legal side. And that's what I was trying to say. I wasn't at all trying to say that she either hadn't done the legal side or that I thought she shouldn't.
Can we look, please, at poll 0038 1455? This is a note of a meeting slightly earlier, 31st of July 2013, between Alice Perkins and Susan Crichton. Can we look at you're not present.
No.
But you were sent this note.
Yes.
At C poll 0038 1460. If we look at the bottom of the first page, please, the bottom two paragraphs. The board had been unsighted on the issue. They'd naturally been alarmed when they found out what had happened, and the fact that the board paper had been so bland and had not helped to build their confidence in the handling of the affair. There'd been the possibility of a discussion on a board call the previous week, but because we had needed to discuss issues in relation to the strategy and funding negotiations with the government, which required board decisions, these had to come first, and we run out of time for the second site issue before people had to leave the call. In the course of what followed, the following points were made. Susan Crichton said that she now thought it had been right to have the inquiry, as it revealed the imbalance of power between the postmasters and the post office, which needs addressing. This was a huge and complex issue for the business. Alice Perkins, commented that I thought that although the outcome had in some ways been good for the post office, the way the process had been handled had been deeply flawed. I backed Susan Crichton's judgment on the appointment of Second Sight because we did not want to appoint one of the big four. She seemed very confident in them, and given her strongly stated opinion to having an inquiry in the first place, I'd wanted her to feel some ownership of the process. Once we decided to go down that route, we'd lost control of the process. I'd lost confidence in Simon Baker early on, but had been told repeatedly he was good and capable of handling the role. I said we should never have got into a position where we didn't see the draft of Second Sight's report until days before its publication, complete version Friday before Monday publication. I understood that Second Sight's investigation had to be independent, but in the civil service, there would have been someone marking it who was close to all the key people. Second Sight, James Arbuthnot, JFSA, and knew what was going on. By the time I'd found out that Second Sight had in effect changed the terms of reference to which they were working, it was too late to retrieve the situation. The organisation and people in it should have had proper time to consider Second Sight's findings and respond to them. Susan Crichton questioned my understanding of the endgame and said the post office had seen the report days earlier. She'd been contacted by the CEO while unwell about this and had come back early from holiday to handle it, which had not been ideal. And then next paragraph, Susan Crichton said that as a lawyer, it was inappropriate for her to influence key stakeholders. She would have been criticised had she become close to them. I commented if she felt unable to play that role, it should have been flagged up and that someone else could have been brought in to perform it. Privately, I'm astonished at this view, which I simply do not recognise from my experience elsewhere. This is what you were referring to, isn't it? When you said of Susan Crichton, she had put her professional conduct requirements and her integrity as a lawyer above the interests of the business.
I was, no.
She'd not marked these people properly, had she?
I'm sorry, those are Alice's words. I've never used that. What I was referring to is that she had, as other directors around the group executive did, responsibilities for delivering work, and this was a particular project or process, as Alice calls it here, and it hadn't delivered to time, to budget. The board felt rushed in terms of seeing it. They hadn't. Normally, a report like this from an independent consultancy, as we saw earlier on Deloitte, for instance, would come to the board. There would be discussions around it. There would be interim discussions, drafts, etc. although the business had had it days earlier, it was only days earlier before it came to the board, and the business itself hadn't had that opportunity. So my comment was not about Susan marking anybody, it was simply about how she managed that balance of her legal responsibilities and her responsibilities to deliver a key business project.
So the chairman of the business is saying that in the civil service there should have been somebody marking the key players. The lawyer says it would be inappropriate for me to influence the key stakeholders because of my professional obligations.
But also,
the chairman is astonished at that view, and then you wrote a note which said the lawyer put her professional obligations above the interest of the business. But that didn't refer to this. Is that what we're to believe?
Yes, I'm very clear what I meant about that, and I think I also say somewhere else that if Susan felt, but it's what Alice says here too, is that if she had felt conflicted in that way, then she could have mentioned it to me. And when I had the conversation with her, I think at the end of July, we talked about giving her more resource so that she could have the support to deliver the project.
You and the chairman were annoyed that Susan Crichton, who had led on this project, had not influenced or massaged the key stakeholders in a way that was favourable to the post office, weren't you?
No.
She hadn't marked them close enough.
That's what the chairman said. That was not my view. Susan wouldn't have been able to influence Second Sight on a number of the areas that they were critical of the post office on, because a number of those areas were related to operations. Susan was a lawyer, not an operations manager, but she was the director who was overseeing the project, and the project was late.
So it's a coincidence, is it, that on the 31st of July, the chairman is writing a note about a conversation that she's having with Susan Crichton, which involves the lawyer's duties and whether it was appropriate or inappropriate for her to mark the key stakeholders. A month later, you wrote a note which said that, in your view, she had allowed her professional obligations and integrity to come above the interest of the business. But that note didn't refer to this at all and was, in effect, a misunderstanding between you and the keyboard.
Between me and?
The keyboard you were typing on.
I've already explained to you that what I was trying to convey in that comment. I would, and I don't think Alice Perkins would either, have wanted Susan to compromise her professional code. But Alice can speak for herself. My view, I was being heavily criticised by the board because the business hadn't delivered this project to budget and to time, that there were serious complaints within the report that the business said it hadn't been able to deliver its evidence on. And the individual who was overseeing that work from the business point of view was Susan. And that was all I was trying to say, is that she needed to be able to do both, and I was happy to support her to do that going forwards.
Thank you. Can we turn to a fresh topic, please, which is about the Post Office's attempts to control the narrative. You tell us in your witness statement, it's paragraph 765, there's no need to turn it up, that, quote, the most important outcome for you and the board was to ensure that the Post Office complied with its legal obligations. And you tell us that you genuinely do not believe there was any culture within senior management at the Post Office to prevent the investigation of complaints within about Horizon. Rather, we had to do everything reasonable to investigate the complaints, correct?
Yes.
Can we turn up, please, poll 0029 4854? And and turn to page 2, please. And if we look down the page, please, to the foot of the page, we'll see an email from David Simpson to a group of people. We'll later see, I think, that this email gets sent on to you about Horizon and Private Eye.
Yes, I'm actually copied.
Oh, yes, you're in on this copy. Thank you. And tell us who David Simpson was.
He was the communications director for Royal Mail Group.
Mike, Suzanne, Rebecca, the new edition of Private Eye out today has, as expected, run an article attached about Horizon and the criticisms made by some former sub-postmasters. The names of the sub-postmasters featured are very familiar, and the claims made against Horizon are the ones we've seen many times before. The article mentions shoesmiths and a possible legal action. And then, not surprisingly, Private Eye has not run in full the very short statement we gave them. We think we should write a letter to Private Eye for publication, making two simple points. The fact it's the courts and not the post office that convict people, and the point we made in our statement that the courts have upheld the post office's position in each court case. The draft should say, sir, the post office takes meticulous care to ensure the Horizon system in branches nationwide is fully accurate at all times. We do this because public money is entrusted to the post office and our customers, and so postmasters rightly expect the post office fully to account for every penny. We have full confidence in the Horizon system. There have been, in square brackets, a small number of cases involving a small fraction of the post office network where court action has been taken over missing sums of public money. In every case, courts have consistently upheld the post office position that the Horizon records are accurate and reliable. When former sub-postmasters have been convicted of theft, it's of course the courts that have convicted them, not the post office, which has had to provide sufficiently robust evidence of proof, otherwise the cases would have failed. And then further up the page, please. Susan Crichton says, thank you, my own view and experience, I wouldn't write. This is old news and we don't want to prolong the story. And then your view at the top of the page, Susan, I understand and it's a fine line, but I disagree. We need to be front foot and counter anything that has a reputational impact. It is a goal of mine that all press, even local press, perhaps especially local press, should be scoured for negative comment and refuted. I would only not do so only if Shane or Alana's view it's likely to cause more trouble than it's worth. Why was it important for you at this time to counter anything that has a reputational impact?
This was a general ambition of mine, and the important phrase here is where I say perhaps especially local press. And it's in my statement, and I spoke about it at numbers of conferences. The post office's reputation and its brand was built every single day in post offices across the country by the people who worked so hard serving customers, many of whom were particularly vulnerable people. And so it was important to me that where the post office was misrepresented, that should be corrected, and especially at a local level, because local post offices were so important to people. I think I said yesterday, the reputation of Post Office Limited had no weight at all. It was irrelevant. It was the reputation of the post office, your local post office, and that's what I'm trying to say here. It's an ambition to make sure, because when over a number of years, post offices have been very much a sort of second cousin to Royal Mail within the group. And what we were trying to do now is to start to build Post Office its confidence and to recognise the importance of it in communities. And I think that's what I mean here about that.
And was that your general instruction to the business? Contest all and any negative comments?
I don't think it's a general... It was an ambition, well, only if they were inaccurate.
In the Post Office's view?
In the Post Office's view, yes.
And so that's why it was a goal to scour local press for negative comment, leaf through newspapers and online, actively find negative comment and knock it down.
It wasn't... I didn't commission a piece of work as a result of this. I'm simply stating an ambition for the business here to try to portray the Post Office in a positive way, particularly locally.
What did you mean by that local press should be scoured?
Oh, I think it's a hypothetical statement I'm making to try and illustrate how important it was that the Post Office was portrayed in the way that people loved it and trusted it. It really was
Maybe was.
a very important... I'm sorry?
Maybe was.
I fully accept that this has damaged hugely the Post Office brand, but I imagine if you go to your local post office, you will still find the same level of service and the same level of value, and people will respect that.
Can we move forwards, please, to other ways in which the narrative, I suggest, was sought to be controlled? Poll 0038 0985. If we scroll down, please, we'll see an email from you to a group of senior Post Office executives, amongst which was Susan Crichton, saying my engineer/computer literate husband has sent the following reply to the question, what's a non-emotive word for computer bugs, glitches, defects that happen as a matter of course? Answer, exception or anomaly. You can also say conditional exception or anomaly, which only manifests itself under unforeseen circumstances. Does that help? And Mr. Davis replied at the top, I like exception very much. Did you consider the terms computer bug, computer glitch, or computer defect to be emotive?
I shouldn't have engaged in this at all.
Again, that's an answer to a different question.
No, I realise that, but I want to say very clearly, we should have said bugs.
Did you consider the word computer bugs, glitches, or defects to be emotive?
I'm not sure why I used non-emotive. I think what I was trying to do here, and the inquiry has seen that the conversation had been started some days earlier, and I assume that I was asked. So whether I was asked what's a non-emotive word, I don't know. In my own mind, this seemed it isn't now, I fully accept that, but it seemed a reasonable request because the two bugs that we were dealing with, and this is wrong, but I understood at the time to be not, as I've mentioned before, the word red herring was used. They were two bugs which had been fixed. The business had responded to them appropriately, and I didn't think that what I was trying to do was to avoid what often happened with the Post Office, and I imagine still does, was misinterpretation of something in relation to the second site work and the Horizon computer system where it had been dealt with, and my understanding of the way it was explained to me was that that had been done in the way it should. I should have said bugs. I should not have sent the email. I should have said bugs, and so should the rest of the organisation.
Did you and your senior Post Office colleagues call these things bugs, glitches and defects during your internal meetings? Or did you call them exceptions and anomalies?
I think we've seen numbers of different descriptions.
Before this time, did you call them bugs?
There was certainly, I think when Alwyn Lyons phoned me to tell me about it, I think she said we found 2 bugs. Or, I'm not sure. But,
Why did you ask your husband for non-emotive words for computer bugs, etc.?
because we were looking to find a different word than bugs.
Yes, but why?
Because, as I've just tried to explain, wrongly and stupidly, and we should have said bugs, we were trying to keep the proportionality, I thought, around 2 issues that had arisen that were not anything to do with the systemic impact on the system or the second site interim report.
Did you initiate this discussion, or was it one of the recipients to your email?
I think it had been initiated beforehand, because I think the inquiry's seen a note from Alwyn, but I don't necessarily want to suggest that it was Alwyn initiated it. But her note where she talked about incidents was a few days before this.
Did this become part of the Post Office's communication strategy?
The words were picked up, yes. Anomaly was picked up, and exception was picked up. Strategy is probably too strong a word, but yes, the words were adopted.
You were seeking to manipulate language here, weren't you?
Yes, we were seeking to use language that I thought described better the situation and avoided confusion and conflation with something that I viewed as completely separate.
You thought that using the word anomaly or exception would help people to understand that a problem with a computer, which was a bug, a glitch, or a defect, had limited impact.
Yes, because that was how I understood it, that these were anomalies or exceptions. They were bugs.
And why do you think you got this wrong then now? You said, sorry, you shouldn't have asked this, you shouldn't have done this. But if what you're saying is true, it was entirely appropriate.
It was, and that was why that was why I engaged in doing this.
So why are you apologising?
Because with hindsight, it was wrong.
But why with hindsight? What was wrong? If what you're saying is true, that you'd been told that these 2 bugs had this very limited impact, they were red herrings, why are you apologising?
Because what I've learned since is that there were many other bugs in the system that affected restricted numbers of branches that equally could have been described as anomalies or exceptions. And in fact, what these were manifestations of was an instability in a system that I wasn't aware of.
You were involved consistently over the years in the development and agreement to the Post Office's media strategy in relation to Horizon, weren't you?
Yes, the communications director worked with me.
So this email can come down. Can we look, please, at poll 0011 1694? We're quite late in the piece here, February 2019, so a couple of months before you left. And if we look at the foot of the page, please, you'll see an email from Tom Cooper at UKGI to, amongst other people, you. Can you see that?
Yes.
And he asks, second paragraph, to what extent can the court protect the Post Office against journalists overstating the evidence re Horizon? if a journalist writes that there's evidence of systemic problems with Horizon, when in fact no such evidence exists? Will the court help us? To me, extremely important to have a press strategy that seeks to stop misrepresentation by journalists and seeks to protect the Post Office's business today against the implication that the current system doesn't work properly. If we just look at your reply at the top of the page, please. You say, yes, we defend robustly, but we avoid adding extra coverage. As before, we hold the ground. The system is robust. And not comment any further during the trial. So aggressive, no. Robust, absolutely, no question. We're trading well. We'll continue to trade well. The system works, and the trial doesn't change that. A very firm line. This was still your approach in February 2019, correct?
It was. The system that I was referring to here, though, is the system that was introduced, I put 2010, but actually it was 2017, I think. And Judge Fraser found that that was had far more integrity than the other previous the Horizon Online and Legacy Horizon.
Next paragraph, but one, the strategy has worked well so far, which is to minimise coverage in mainstream media. But was that the Post Office's approach even in 2019? Minimise coverage?
Yes, I think it was, because there was always this concern, as Tom Cooper himself said in his email, about trying to manage misrepresentation in the media, and that so that the chronology wasn't confused between Legacy Horizon and the current Horizon. And I can't remember at this stage, but I don't believe the company had yet gone through the Horizon trial.
And then penultimate paragraph, your questions re how far we go legally are important. We've used injunctions and demanded apologies in the past. When had you used injunctions in the past?
I'm not sure, actually. I may have got that wrong. There was a... I know Mark Davis had had conversations with some media, and lawyers had been... I think he had maybe sought advice from lawyers, but I don't think we had used injunctions, actually.
Had you threatened the BBC with injunctions?
We had certainly considered legal advice at the time where people thought the coverage was wrong.
And demanded apologies in the past. Is what you say here reflective that in your tenure as CEO, you had always defended Horizon robustly, that you had taken a very firm line with the media, including threatening injunctions and demanding apologies?
You won't find that I asked about injunctions. That was, I think I was informed about that, as the board were informed about it. But yes, certainly demanded apologies where the business felt that it had been misrepresented, and defended Horizon, yes, because, again, I had confidence in the system. I regret that hugely now.
Can we turn to poll 00184390? And look at the foot of the page. An email from Alan Bates to George Thompson at the NFSP. Dear Mr. Thompson, so close to Christmas and with delays in the mail, I've attached a PDF of a letter to you which is self-explanatory about a forthcoming investigation into the Post Office Horizon system, which I believe will benefit your members. If you so wish, it could be published in the Sub-Postmaster magazine. Once January arrives, there'll be significant press coverage about this investigation in order to ensure the widest possible audience is reached. This is about Second Sight, isn't it?
Yes. Yes.
And so Mr. Bates, writing politely to a leader of the NFSP, saying there's an investigation into Horizon that might be of benefit to your members. Maybe you could publish it in the Sub-Postmaster magazine. Quite reasonable, really. You agree?
Yes.
If we scroll up, please. Email to Nick Beale, Kevin Gilliland and you. Hi, Nick. I've just received this rubbish from JSA. Obviously, I'll tell him Horizon is secure and robust and to go away. Just keeping Post Office in the loop. The NFSP weren't supposed to be the cheerleaders for Horizon, weren't they?
The NFSP, including their executive council, were all sub-postmasters, and they would have fallen into the overused statement about the majority of people didn't have problems with Horizon. So I imagine they reached this conclusion from their own personal experiences.
Really? Or were you just happy to have a tame and pliant NFSP in your pockets?
It was very helpful to have the General Secretary of the NFSP saying that Horizon was secure. I didn't use Horizon every day. His wife did in their post office, and his colleagues were also running post offices. So for me, I don't agree with George's style, but this is
Rubbish.
very much, yes, with hindsight it is, isn't it? But George was quite independent of mind.
And who paid the NFSP's bills?
At this stage, I'm not entirely sure, but the post office certainly made a contribution towards them, I think a little bit later than this. They lost their status as a union.
Penultimately, can I quickly address your approach with government and MPs? You tell us, this can come down, sorry, in paragraph 42, that there were no government representatives on either the Post Office Board or the Royal Mail Group boards when you first joined the Post Office, but that had changed by the time you became MD.
No, by the time I became Chief Executive.
I see. So in 2012?
In 2012, post-separation.
And can you recall who they were from time to time?
The first government non-executive director was Susanna Hooper, who became Susanna Story.
Was that between 2012 and 2014?
I think so, yes. Then it was Richard Callard, and then it was Tom Cooper.
Mr. Callard, 2014 to 18, Mr. Cooper, 18 to 2023.
Right, thank you.
You tell us in your witness statement that the Post Office Board met with government officials in SHIEX and UKGI, and that their non-executive directors were active in their challenge and contribution to board meetings. Is that right?
Yes.
In your view, were SHIEX and therefore the government aware of the views of Alan Bates and the Justice for Sub-Postmasters Alliance through the Post Office?
Yes, I think so, particularly because the work had been started by Alice Perkins, and Alice was personally quite involved and would often join in briefings of the board, so I'm sure they would be. And also there were, at an executive level, fairly regular contacts with officials in SHIEX, what then became UKGI as well.
Were they aware of the interest and activity of Lord Arbuthnot in the cases of individual sub-postmasters and with the Horizon system generally?
I believe so.
Aware of the involvement of Second Sight and the work carried out by them?
Yes.
Aware of the concerns which the Post Office had at the time about the nature and quality of Second Sight's work?
Yes.
Aware of the concerns raised about the reliability of some past convictions?
Yes.
Were they made aware that advice had been obtained from Cartwright King and Brian Altman Casey?
Yes.
aware of the involvement of and a summary of the advice of Linklaters?
Yes.
Were they aware of the fact of the group litigation and the Post Office's strategy in the group litigation, including the decision to apply for the recusal of Mr. Justice Fraser as he was?
Yes.
Were you a party to the decision?
Sorry, just on that last point,
Yes.
if I may, because of a family situation, I had to step back from my role as chief executive sort of from January 2019 onwards. I was involved sort of in and out of the business as we were going through hospital visits, and then stepped back much more from March. So I wasn't always in the meetings where the board discussed the recusal, but I'm fairly sure there are board minutes that list that Richard Callard or Tom Cooper was present at the time.
That was the last topic I wanted to ask you about. I think you, is this right? Although you make the point that you just have, that through personal circumstances, your involvement in the strategy and direction of the group litigation diminished in the course of 2019. Is that right?
Yes, that's right.
You, nonetheless, I think, were on the call in which a decision was made to ask the judge to recuse himself.
No, that's not quite right. I joined a call late, and just for clarification, there is documentation that says that Tim Parker didn't know that I was on a particular call. It's because I joined late. He did know later on. I told him about that. And I'd been asked to join the call. I think he and possibly Tom Cooper had to recuse themselves from that decision, which was taken later than the call. And I'd been asked to join that call by Al Cameron and by Ken McCall, who is the SID.
And you joined silently, is that right?
I joined silently, yes.
Without anyone knowing that you had joined?
Ken McCall and Al Cameron and possibly Jane McLeod knew, but I wasn't sure that I was going to be able to join it at all, and I didn't take part in. I left the call, and the discussion about the recusal took place either later or on a different call or a different meeting.
Can we look, please, at PVEN 400505? And then next page, please. I think these are a series of communications between you and Jane McLeod, is that right?
Yes, that's right.
Are they texts or some other form of communications that you cut into a Word document?
I think... I imagine they were texts. Yes,
anyway, second one
yeah,
down, whatever
yeah.
medium
Yes,
was
yeah.
used to communicate, you sent a message at 4 minutes past 1 on the 20th of March, and you say, Jane, I was listening on the earlier call. I get the impression Tim intends to join the main board call now. Obviously, he doesn't know I was on the earlier call. Can you let me know if you still want me to give a view? Thanks, Paula. Jane McLeod, sorry, Paula, I wasn't watching my phone, didn't see your message. The board has approved both the appeal and the recusal. Happy to discuss it if it helps. And then you, thanks, I'm pleased. And then further down, apologies, been running around getting things going. And then later at 11:33, hi Al, any chance of a quick call? This is to Mr. Cameron. As Tim and Tom are excusing themselves from the recusal decision, and as Ken is very worried about chairing it, she asked if I might offer a view by email and caveated, of course, I'm prepared to do that, but as you know, I'd normally consult widely on something this serious. We can talk before or after the Lord Grabbanner call.
Yeah.
And then scroll down. If we look at the next page, there, if we just get the date by just scrolling up a little bit. I think it's the 21st, the next day, and then scroll down. You to Mr. Davis. I felt the same about the board. Very proud and pleased. Difficult, but completely the right decision. The opposite would have been unconscionable after what both Lords Grabbanner and Neuberger had said.
Yeah.
Had you listened to what Lords Grabbanner and Neuberger had said on the call?
I only listened on one call, and I think that was presumably the Lord Grabbanner call. I had conversations with, these would have been phone calls because I wasn't in the office, with Al Cameron, I think Ken McCall, and Jane MacLeod. So I may have heard what Lord Neuberger said through them.
Not directly, but indirectly.
I don't think so, yes. Yeah, indirectly.
Overall, was the board keen to take these decisions, to recuse and to appeal?
It was really difficult. I mean, I've said this here. It was and the inquiry has documentation on it. It was a very, very difficult decision. Nobody really quite knew what to do, but the views that came through from Lord Grabbanner that I heard, and I think what I heard about from Lord Neuberger, and again, you have documentation on this, were very strong, that the Post Office had a very good case, and the board took that decision.
Why were you proud?
Because I think it took so I knew the colleagues around the board table. This was about the people around the table, not anything more than that. They were being asked as individuals to take an extraordinarily difficult decision to ask a judge to recuse himself, and I think it was also about appealing the case. And they're decisions that nobody in their professional life wants to be involved in, frankly. They're very, very difficult. And
why were you pleased?
Because I think had I been involved in the conversation, I probably would have arrived at the same conclusion.
Thank you.
Thank you.
Ms. Vennells, they're the only questions that I ask. You'll be asked some questions tomorrow by call participants. Thank you.
And speaking of tomorrow, Mr. Beard, I understand that you've agreed a timetable with the co-participants. We needn't address it now, but it's all in hand. For personal reasons, I will not be participating in the room, but participating remotely. But I fully expect that the excellent behaviour which has prevailed throughout the course of the day will continue, notwithstanding I'm on a screen as opposed to sitting here. I have an easy means of controlling you all, even on a screen, but Mr. Beer will act as my adjutant, or whatever the correct army term is, in ensuring that things go smoothly. That's tomorrow. Just one or two other announcements. Firstly, some people are aware, in fact, you may all be aware, that the lady you've heard about, Miss MacLeod, is not willing to come and give oral evidence to the inquiry. I think I indicated to co-participants through the Secretariat or my legal team that we would provide an explanation for that. If I haven't done that, I'm now telling you that we will provide an explanation in writing, which should be with you tomorrow. And the final announcement I wish to make is that you may have heard there's going to be a general election shortly. My view currently is that that will not interfere with the timetable of the inquiry, save for the day of the election and the day after. I have decided that we will not sit on July the 4th and July the 5th. But subject to that, I propose, so far as is humanly possible, to continue as if the election is not occurring. And so those are the announcements that I wish to make. And tomorrow we'll start again at 9:45. Thank you.
Thank you, sir.